nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh-lebo, rasa girang dan badendang pulange. Floba mora tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh-lebo, rasa girang dan badendang pulange. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh-lebo, rasa girang dan badendang pulange. Mora tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh-lebo, rasa girang dan badendang pulange. Meski beta lama jauh di rantau orang, beta ingat bama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi lenusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa girang dan badendang pulangnya. Bamora tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi lenusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat bama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi lenusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa girang dan badendang pulangnya.
Assalamualaikum warahmatullahi wabarakatuh. May peace be upon us. Ladies and gentlemen, welcome to day 2 of the 6th Indonesian Constitutional Court International Symposium, or the 6th ICCIS 2023. I hope you had good rest last night, and now we are about to start the session 3, and it will be chaired by Ibu Diana Puspitawati, PhD, with the subtheme Threats to Judicial Independence, posed by populist movements. And there are two speakers, and the respondents already stayed there next to chair. So without further ado, the floor is yours, Ibu Diana Puspitawati, PhD. Thank you.
Thank you. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. I hope you have a good sleep last night. And first of all, I would like to thank Pak Pan Muhammad Faiz for making me the only female chair in this conference. And it make me very nervous, actually. So ladies and gentlemen, this morning we come to session 3 and we have 3 speakers, Professor Manuel Adrian Merino, Professor Sultan Sente, I hope you pronounce the name right, and Dr. Idus Risan. But for the first speaker, I will invite Professor Manuel Adrian Merino Menjiva. I believe he's already on the Zoom. Right?
Yes, hello, can you hear me?
Yes, but I cannot see your face. Maybe the committee can make Professor Morino appear on the screen. Okay, Professor Manuel, can I call you Professor Manuel or?
Yeah, sure, of course, just Manuel, no problem.
Okay, good morning, Manuel. I will not read again about the rule, but you have 15 minutes to present your paper. Since you present online, would you mind if I remind you about the time during your presentation? Is it okay, right?
Okay, no problem.
Okay, thank you. So without further ado, first of all, I will introduce the respondent. We have Dr. Oli Viana Agustin from Constitutional Court of Indonesia and Dr. Anna Triningsih from Constitutional Court of Indonesia. So Professor Manuel, without further ado, the time is yours.
Okay, thank you so much. Just let me try to play the presentation I have prepared. Can you tell me if you are seeing it now?
Yes, we can see you.
Okay, thank you so much. So good morning in Jakarta. It is still the evening of August 10 in El Salvador. It is a true honor for me to give this presentation for the Constitutional Court of Indonesia. Thank you so much for the invitation, and thank you to the committee for organizing this magnificent event. So in this opportunity, I will talk about the removal of the Constitutional Chamber Justices in El Salvador, my country, which is the title of the paper I presented for this symposium. I will not discuss the removal in general, meaning the causes and procedures that can be used to remove the justices, but rather the specific events that occurred in El Salvador on May 1st, 2021, where the Legislative Assembly, aligned with the President of the Republic, decided to remove the Constitutional Chamber justices, even though they still had 6 years remaining in term. For my presentation, I will basically follow the structure of the paper. So, first, let's take a brief overview of the Salvadoran constitutional design. The current Salvadoran constitution was enacted on December 16, 1983, while the country was going through a 12-year-long civil war that would end in 1992. Despite this, I may say it is a good constitution, a classic Latin American constitution that encompasses an extensive catalog of fundamental rights, including social rights, and adopts the basic principles of liberalism. Regarding the form of government, the Constitution recognizes that El Salvador has a republican, democratic, and representative form of government. As a main component of this structure, it acknowledged the principle of separation of powers. Article 86.2 established that the fundamental branches of the state are three: the legislative, the executive, and the judiciary. The main functions of the Legislative Assembly include enacting laws and constitutional amendments. The executive branch is headed by the President of the Republic, who is elected by popular vote and is in charge of conducting the public administration. And the judiciary branch is responsible for adjudicating conflicts in various matters, and it is composed of the Supreme Court, the appellate courts, and the ordinary courts. About the judicial review is exercised by the Constitutional Chamber, which is within the Supreme Court, and it is composed by 5 justices. The main powers of the Constitutional Chamber are to hear cases of unconstitutionality of laws, to hear cases of amparo, and to hear cases of habeas corpus. We also have a system of diffuse judicial review following the American style, which authorizes all judges in the country to declare inapplicable any law, decree, or international treaty that contravenes the content of the Constitution. So let's talk about the democratic degradation in El Salvador, and I will give you a tour of some practices of constitutional authoritarian populism between 2019 and 2023. But first, let me tell you in few words what do I understand by constitutional authoritarian populism. This concept is the result of the combination of what I call a very Latin American formula, that is, the sum of abusive constitutionalism plus populism plus authoritarianism. Abusive constitutionalism, as defined by David Lando, involves using constitutional change mechanism to undermine democracy, resulting in a less democratic state than before. Populism, on the other hand, is a thin-centered ideology that pits the pure people against the corrupt elite and emphasizes the general will of the people in politics. In Latin America, populism has found fertile ground due to historical challenges such as poverty, inequality, and corruption, leading to the rise of charismatic leaders promising to give power back to the people. However, many of these leaders have used constitutional change and other tools to solidify power and eliminate checks and balances, leading to authoritarian regimes. In the region, leaders like Hugo Chavez in Venezuela, Daniel Ortega in Nicaragua, and now Nayib Bukele in El Salvador, among others, have come to power through legitimate means and then use constitutional mechanisms to disrupt democratic regimes. They may appoint sympathetic judges to courts and neutralize opposing judges through bribery or threats, eroding judicial independence and consolidating their power. Constitutional authoritarian populism has been a preferred method for some leaders to stay in power for extended or undefined terms, even when constitutions explicitly prohibit it. In some cases, as in Honduras, Nicaragua, Bolivia, and El Salvador, highly politicized and non-independent constitutional courts have been allies in achieving this purpose. This combination of populism, abusive constitutionalism, and authoritarianism poses significant challenges to democracy in Latin America. So I want to give you a little context to understand what happened in my country. In 2019, a young and popular politician called Nayib Bukele founded his own political party called Nuevas Ideas, or New Ideas in English. He ran for president of the Republic and won with a landslide. Bukele always used populist rhetoric to put an end to all traces of the corrupt parties of the past and any other enemy that hindered change in El Salvador. Among those enemies was the Constitutional Chamber. The political party New Ideas was the necessary vehicle to access another branch of the state, the legislative. On February 28 of 2021, as a historical event, the political party New Ideas won 56 out of the 84 seats of the Legislative Assembly. That is the majority required by the Constitution to take almost any important decision, as to elect the Attorney General, the Ombudsman, and the Public Defender Officer. And, of course, elect the justices of the Supreme Court, including the 5 justices of the Constitutional Chamber. So the first act of what I call constitutional authoritarian populism was the armed takeover of the Legislative Assembly. On February 9, 2020, the President of the Republic chose to militarize the Legislative Assembly to enter it, to force the deputies to approve a loan of $109 million to address public security issues. Once seated in the position of the President of the Legislative Assembly, he expressed that he would be patient, offered a prayer to God, and left the place. Although it did not go further, the symbolic significance of this act was evident. Later, this act was declared unconstitutional by the Constitutional Chamber. The pictures you're watching in the presentation are real pictures of that day. Also, another act is the abuse of power during the COVID-19 pandemic. In El Salvador, the pandemic exposed an abuse of power by the executive branch in 2 ways. The disregard for constitutional rules that allow for the declaration of a state of exception or emergency, and on the other hand, the widespread violation of human rights through the practice of arbitrary detentions disguised as quarantine measures, based solely on the fact that people were out of their homes. These acts also were declared unconstitutional by the Constitutional Chamber. This decision angered the President of the Republic, who publicly stated that he would not comply with them. Let's talk about the role of the Constitutional Chamber of El Salvador in controlling political power. In its recent history, especially from the period of 2009 to 2021, the Constitutional Chamber of El Salvador was characterized by playing an active role in controlling political power. To mention a few examples, through its judgments, it declared unconstitutional constitutional amendments, declared unconstitutional the general budget of the nation, declared unconstitutional the appointment of public officials based on their affiliation with political parties, declared a state of unconstitutionality due to overcrowded conditions in the country's prison, declared the amnesty law unconstitutional, granted amparos obligating the public healthcare system to provide adequate medical treatments, among many other relevant decisions. All political actors became aware that an independent and technical constitutional chamber was the greatest obstacle to fulfilling purposes that deviated from the framework of constitutionality. Well, wait. So about the removal of the Constitutional Chamber justices and what I call a faithful nightfall democracy, the first session of the Bukele's Legislative Assembly took place on May 1st, 2021. In a session that lasted more than 6 hours between the evening of May 1st and the early morning of the following day, a surprising proposal was made by some deputies of the majoritarian party to remove the Constitutional Chamber justices. The arguments in which they based their proposal were, in summary, that the Constitutional Chamber issued a series of arbitrary judgments out of the range of its competence, that they violated the separation of powers, and that they put into risk the health of all Salvadorans by ruling against the measures taken by the government to fight COVID-19. All that was false. No due process of law was followed for their removal. In the incredulous gaze of the entire population, who were following the session of the Legislative Assembly through various media outlets, in the blink of an eye, the new lawyers were already being sworn in to occupy the position of justices of the Constitutional Chamber. So the question is, did the Legislative Assembly have the power to remove the justices from the Constitutional Chamber? In a normative sense, the answer is yes. Article 186 of the Constitution grants the Legislative Assembly not only the authority to elect justices of the Supreme Court, including those of the Constitutional Chamber, but also to remove them with the vote of 56 deputies. The same Article 186 established that the causes for which the justices can be removed must be previously established by law. This is a case of what constitutional theory have called a constitutional mandate. The law that should regulate the causes for which justices could be removed from the constitutional for the Supreme Court did not exist at the time the Legislative Assembly decided to remove them, and it still does not exist at this time. These acts carried out by the Legislative Assembly have been characterized as a typical case of constitutional authoritarian populism.
Excuse me, Professor, you have 2 more minutes?
Okay. So let me finish with this idea. So the reaction of the removed Constitutional Chamber, they tried to declare unconstitutional their removal, but the decision was not obeyed by any authority. And finally, why I say the history repeats itself is because the Salvadoran Constitution prohibits presidential re-election to such an extent that the rule prohibiting is considered an eternity clause. And many other articles of the Constitution confirm this prohibition. Despite this, the new judges of the Constitutional Chamber, in their first opportunity, allowed the presidential re-election. The arguments used were so absurd that they were barely comprehensible. This is one more case in Latin America of the modification of the presidential term limits through the interpretation of constitutional courts, as in the cases of Bolivia, Costa Rica, Honduras, and Nicaragua. And my conclusions of all this is that an independent constitutional court is often the greatest counterbalance to power in a constitutional democracy. That is why both domestic and international regulations ensure special guarantees for those holding the position of those judges, especially for constitutional judges. Among these guarantees is stability and tenure in office, which mean that they can only be removed for legally established reasons and through due process of law. What happened on May 1st, 2021 in El Salvador is a perfect example of how power under the influence of authoritarian populism that simulates acting within constitutional rules can undermine any remaining democratic element that pose obstacle to complete concentration of power. Thank you so much.
Thank you so much, Professor Manuel from Gerardo Barrios University, El Salvador. I think what we have discussing is about Constitutional Chamber of Justice, that this issue seems to happen everywhere in the various constitutional court from many countries. So our first and beautiful respondent is Dr. Oliviana Agustin from Constitutional Court of Indonesia. The time is yours. We have 10 minutes for 2 respondents. So yeah, 5 minutes each. Okay, Dr. Ali.
Thank you so much, Ibu Dr. Diana. And good morning, Professor Manuel from Jakarta. In your paper state that the essence of the Constitutional Court lies in the counter-majoritarian nature, with their function of declaring laws and other act unconstitutional clashes directly with the will of those who hold political power and with the will of the majority whose interests are often represented by the member of the parliament or legislative assembly who were democratically elected. From the statement, I would like to get more information first. Is that the Constitutional Chamber of El Salvador currently quite active in its decision which disrupt the interests of the legislative and executive? And in your paper, said that the concept of constitutionalism, authoritarian populism, which depart from the Nueva Idea political party, if I'm not mistaken in pronunciation, which is developing in America Latin. And the second question is, Article 186 in your Constitution grants the Legislative Assembly not only the authority to elect justices of the Supreme Court, including those in Constitutional Chamber, but also to remove them. Related to this article, I'm interested in knowing more about how many constitutional justices are in the Constitutional Chamber, and are all the constitutional justices elected from the Legislative Assembly. If I can compare with the Indonesian Constitutional Court, we have 9 constitutional justices with elected by 3 institutions like a Legislative Assembly, President, and the Supreme Court. Thank you.
Okay, Professor Manuel, you can respond to the first respondent first, and then after that we move to the second respondent. Thank you.
Okay, thank you for the questions. I had a little problems to hear clear the first question, but with the things I heard, I can tell you that the new judges appointed as Constitutional Chamber justices were people who are not considered in my country as independent judges, because they were related to the majoritarian party, as you well said, Nuevas Ideas, or new ideas. And the most important thing is that no due process was followed to elect these new constitutional judges. So they have a lack of legitimacy. So if the constitutional courts are criticized by this counter-majoritarian aspect, because many scholars say that they have no democratic legitimacy because they were not elected direct by the people. So imagine these judges that just were appointed with the preference of the president of the republic. About the second question, our constitutional chamber is organically within the Supreme Court. So the Supreme Court of El Salvador is composed by 15 justices, and is divided into 4 chambers: the constitutional chamber, the criminal chamber, the civil chamber, and the administrative chamber. The constitutional chamber is formed by 5 justices, which is the way these justices are elected. So the Legislative Assembly elect these justices from a list that is sent by the 15 candidates from the National Judiciary Council, and another 15 candidates from the lawyers associations of the country. So from the list of 30 candidates, the Legislative Assembly elect the justices of the Constitutional Chamber. I hope I have cleared your questions.
Thank you. Is it enough? Okay, our second respondent is Dr. Anna Triningsih. Time is yours.
Okay, thank you, Dr. Diana. Okay, thank you, Professor Manuel, for presenting your enlightening article. I think it writing comprehensively. In your paper mentioned, independent constitutional court is often the greatest counterbalance to power in a constitutional democracy. Moving on from this statement, I would like to find out more about the dismissal of judges by the executive branch without reason. Of course, not in accordance with the principle of independence. So, what are the suggestions that something like this doesn't happen again? Thank you.
Can you please repeat the last part of your questions? I couldn't hear it well. Please.
Okay. What are suggestions that something like this, something happen against about dismissal of judges by the executive branch without a reason, of course, and not in accordance with the principle of independence?
Yeah. So in the case of El Salvador, the Constitutional Chamber justices were dismissed or removed not directly by the executive branch, but indirect by the by the executive branch. They were dismissed by the Legislative Assembly, but the Legislative Assembly were formed with a majoritarian deputies aligned with the President of the Republic. So they were not independent also, the deputies. They were not a real counterbalance to the executive power, and the complete system of checks and balances were not functioning. So they already have the power of the executive branch and the legislative branch, and by dismissing the judges from the constitutional chamber, they obtain the power of the branch that was remaining, that is the judiciary branch, with the most powerful court of the judiciary branch, that is the constitutional chambers. So this is the effects of this are very, very strong. I mean, there is no real checks and balances in El Salvador. There's not a real counterweight to political power, as I said in my paper. And the proof is that the first decision that the constitutional chamber, the new constitutional chamber issue, was allow presidential re-election, even when the Constitution of El Salvador expressively prohibits constitutional re-election. So after that, the constitutional chamber hasn't issued any decision that controls the power of the executive branch. And obviously, there has been a lot of acts by the executive branch that could be challenged before the constitutional chamber, but the constitutional chamber is just sleeping or doing nothing. Thank you.
Okay, it seems like court independence and judges' composition is always a hot issue to be discussed in any international conference. So I will continue to the question and answer session. Yesterday we seem to forget the online audience. So first of all, I will give the chance to online audience, the audience which is in Zoom, to ask questions. Can the committee pop out the? No, there is no question because I cannot see whether there is a question or not. No? Okay, so I will invite the question from the audience in this room. Is there any more question? Okay, Dr. Monica, we will go to the questions, all the questions, and then give opportunity to Manuel to answer. Thank you. Okay, Monica.
Buenos días, Manuel. Buenas tardes. First of all, thank you very much for your presentation. It's actually really interesting to learn more about the intricacies of how the removal of the judges in El Salvador occur. During your presentation, you talk about this first attempt of judicial resistance, that after the removal of judges, they also declared this act of the Legislative Assembly as unconstitutional, but unfortunately, the decision wasn't complied by the authorities. But also I'm aware like civil society organizations also reacted to this specific legislative and executive political threat against the judiciary in El Salvador. So I was just wondering if you could please share with all of us what has been the role of civil society organizations in order to resist this kind of political influence over democratic institutions in your country. Thank you very much.
Okay, the second question maybe Bapak Fritz.
Thank you, and good morning, Professor Manuel. Buenos dias. So, my question is about the context. I mean, how could be a new guy become a political party leader and become a champion? I mean, it is related about the number of the political parties, because sometimes, at least from Indonesia experience, we try to make political parties small. We try to reduce the political parties because we do not want the headache to have the many political parties. But the other side, when you have smaller number of the political parties, there is a controller. There is a possibility to control the political fight, and how it could be possible in El Salvador, at least from the Latin America, because the populism is like in Brazil, maybe in also Monica will explain later how it could be happen in Mexico. How is the popular leaders could be arise and become a champion in that area. Thank you, and thank you for your context. Thank you, Professor Manuel.
Okay, Professor Manuel, can you answer the questions?
Okay, thank you so much. First, Dr. Monica, buenos dias. So the first part of the question is very interesting because for the first time in history, the Constitutional Chamber issued an ex officio ruling. So that time, no citizen filed a lawsuit asking for the unconstitutionality of the removal of the justice. So was the Constitutional Chamber who issued the decision by itself. So unfortunately, it was not complete. So about the role of civil society in this context, there were a lot of lawsuits that were filed by civil society actors and that were presented before the new constitutional chamber. But as you can imagine, the new constitutional justices were not gonna solve a case against themselves. So they dismissed the lawsuits, and step by step the civil society has been criminalized by the government. Now liberty of expression is under threat in El Salvador. There's a lot of people in jail only for expressing their political ideas against the government. And as you can imagine, no one likes to be in jail. So the role of civil society, it's been every time more pacific, and it's dying a little bit more every day. So regarding the second question, in the paper, I give a more standard context of how this millennial guy, Nayib Bukele, got the power and obtained so much power in his hands. So after the sign of the peace agreements or peace accords in El Salvador that would end a 12-year-long civil war in 1992, there were two main political parties that governed from 1989 to 2019. a left-wing party called FMLN and a right-wing party called ARINA. This period, this historical period of El Salvador was characterized by corruption, poverty, and insecurity. About the corruption, out of the 6 former presidents of El Salvador, 5 have been prosecuted either civilly or criminally for acts of corruption. And the other one is dead. So maybe he could have been prosecuted too. On the other hand, El Salvador, for many time, were the most violent country in Latin America and one of the most violent countries in the world. So this guy, Nayib Bukele, created his own political party, and the slogan that made him win was give back what you stolen. That in Spanish would be devuelvan lo robado. So it was populist rhetoric. He wanted to eliminate all traces of the old political parties. People hated all these old political parties, and they wanted a new figure who can make better things for the country. So this messianic figure of Nayib Bukele
Okay,
appeared.
excuse me, Professor
Um,
Manuel.
yeah.
Still have we run out of time, but one more minute, I think.
Okay, so yeah, yeah, that's the context how this guy, this millennial authoritarian, as some call him, rise to power, and how he is governing right now in our country. Thank you so much.
Okay, thank you. Thank you so much. I know we still have many questions to be discussed, but unfortunately we ran out of time. So thank you, Professor Manuel, for attending our conference and sharing your thought with us this morning. Thank you. Let us give applause to Professor Manuel once again. Thank you. Thank you. Now we move to the second questions. Thank you, ladies, for accompanying me here in the first session. It really made my day. Okay, I invite Professor Zoltan Sehte from Institute for Legal Studies, Center for Social Science, Budapest, Hungary. Unlike previous session, in this session we have 3 respondents. May I invite Dr. Monica Castillejos Aragon from the University of California, Berkeley School of Law, the United States of America, Dr. Mary Christian Putri from Indonesian Constitutional Court, Miss Titis Andindya Jati from Indonesian Constitutional Court. Please come forward. Okay, now we will have our second speaker, Professor Zoltan Sehte from Institute for Legal Studies, Center of Social Science, Budapest, Hungary. Professor Zoltan, I think you can look at the time counter yourself, so the time is yours.
PT?
Oh, sorry. The PowerPoint presentation, is anyone can display the PowerPoint presentation of Professor Zoltan?
Okay.
Okay.
Thank you. Dear colleagues, there's a widespread view that democracy is declining around the world, and this trend can be observed even in the European Union, even though the EU was established as an association of European democratic countries. And if this is the case, this process must affect also the role and status of constitutional courts and other equivalent courts, just because the main function of these courts is to save democracy and the rule of law. The challenges to the independence of constitutional courts are therefore examined in detail in the academic literature, but much less attention has been paid so far to the real effects or real consequences for the functioning of constitutional courts. That's why my paper explores how the jurisprudence of the Hungarian Constitutional Court has changed in recent years. I believe that the Hungarian case can be interesting because this court has been fully pegged by the executive power in the last decade. So the question is whether the jurisprudence, the practice of this court, has really changed as a result of court packing. The problem, let's say the theoretical problem, is how to prove the political bias of constitutional court. For this purpose, I mean, to prove it, I have developed a very simple analytical framework which says that government influence can be justified if the practice of a given constitutional court has been substantially changed or is changing. Next slide, please. Yes, this is the picture of the Hungarian Constitutional Court. Next slide, please. So the practice of the Constitutional Court has been substantially changed in a way that can't be justified by legal arguments. And thirdly, this change of practice coincides with the political interests of the governing parties. My research shows, anyway, that in Hungary, all these conditions have been met in recent years. So that's my starting point, that is actually a fully packed constitutional court. Nevertheless, this court has used a variety of methods to serve the interests of, or to support the government or governmental interests. This is probably because the court wants to keep up the appearance of the institutional independence. Therefore, it takes care in some cases to balance political expectations of the government with professional requirements. So for this purpose, this court has developed various techniques which, however, share the common characteristic of ensuring that the will of the government is to be ensured and legitimized in all particularly highly important cases. But what are these techniques? Next slide, please. One of these techniques was to change the dominant interpretation of constitutional provisions in many cases while the constitutional text hadn't changed substantially. In 2021, for example, the court reinterpreted the relationship between the European Union law and the domestic law in order to give more room of maneuver for the government. In the same decision, the court reinterpreted also the constitutional concept of the human dignity, that's the right to human dignity, which had been since 1990 of an individualistic nature, being the source of individual autonomy. But the court sought to redefine the right to human dignity on a communitarian or on community basis, giving support for the government's anti-migrant policy of the day. In support of the government's policy, next slide, another technique was, another technique developed by the court is to define a constitutional requirement of how a contested law should be interpreted or implemented instead of simply annulling it. However, since the subsequent implementation of such laws is no longer brought back to the Constitutional Court, the result of this method is actually the upholding of highly controversial laws. This was the case, for example, with the law giving the Minister of Justice the power to authorize secret surveillance without judicial protection, or when the highly centralized system of judicial administration was criticized, the court set out only very broad and general guidelines or requirements as to what legal guarantees should be provided in the process, for example, of judicial appointments. But in practice, these guidelines haven't been followed at all. Thirdly, next slide, please. In several times, the reviewed legislation was so clearly unconstitutional that the Constitutional Court simply couldn't escape from its annulment. Where a declaration of unconstitutionality was inevitable, the court has on several occasions chosen to annul the law concerned but not remedy the infringement of rights it had caused. For example, when about 10% of the acting judges was removed from their office by reducing the compulsory retirement age of judges, within a year, the court declared the unconstitutionality of this law without any remedy. Or in other cases, the court repealed the unconstitutional legislation only with ex nunc effect, which means that from now, instead of ex tunc effect, without remedying the harms caused by the unconstitutional rule. So in other words, even if the court repealed an unconstitutional law, it has failed to ensure effective or real legal protection for those who suffered from the consequences of such laws. Next slide. Another well-admitted judicial strategy is the silence of the court. On several occasions, when the annulment of legislation would have made some inconveniences for the government, the Constitutional Court simply didn't take any actions for a long period of time, waiting for the dispute to become, let's say, moot case. For example, when the government persecuted the Central European University, which was anyway the best Hungarian university founded by George Soros, an American billionaire, but who, with Hungarian origin anyway, but at that time, Soros was outcried by the government as public enemy. The court postponed the issue for years until that the university was enforced to move from Budapest to Vienna. And finally, 4 years after the dispute, the Constitutional Court terminated the whole procedure as a moot case. Next slide, please. Finally, in most extreme cases, the Constitutional Court changed the previously established constitutional standards or resorted to extra-constitutional sources, or even departed from the constitutional text when necessary, when it was necessary to achieve the desired result of interpretation. There's a whole series of such decisions, some of which paved the way for the government's so-called unorthodox economic policy, while others legitimized decisions directly motivated by party politics. For example, in 2016, the Constitutional Court discovered the concept of constitutional identity, which had been completely unknown in Hungarian constitutional history or constitutional law beforehand. So it was not entrenched by the constitutional text. In fact, the Constitutional Court quickly came to the rescue of the government at the peak of the government's anti-migrant and anti-EU policy or campaign, which sharply opposed the migrant and refugee policy of the European Union. The Constitutional Court also served the interests of the government when, in several decisions, allowed public authorities to lodge individual constitutional complaints with the Constitutional Court if a final judgment of an ordinary court had harmed their interests. So in sum, the Hungarian Constitutional Court operates in a highly politicized way. Just a few months before the parliamentary elections last year, the president of the Constitutional Court issued a statement, let's say a political statement, in which he sharply condemned the opposition party's plans to restore the rule of law and constitutional democracy if they were to win majority in the elections. So in fact, the composition is determined, the composition of the Constitutional Court is exclusively determined by the governing parties, which is possible because the governing parties have a two-thirds parliamentary majority, which means a constitution-making majority in parliament. And the composition or the change in composition of the court has fundamentally transformed the character and jurisprudence of the court from being the supreme guardian of the Constitution and being a very active counterweight of the legislative and executive powers. Let me remind you that the Hungarian Constitutional Court was considered for a long time as one of the most powerful and most activist constitutional courts over the world. So from this position, it has become a submissive servant and legitimizer of the government's will. Apart from the erroneous or a whole series of erroneous individual decisions and the decline in the level of legal protection and constitutional standards, I believe that the most serious criticism of the Constitutional Court is that it has failed to prevent the systemic erosion of the rule of law after 2010. In fact, it hasn't been an obstacle to the authoritarian transition which is going on in this country, but it is its promoter, and thus bears heavy responsibility for the destruction of democracy. And in the end, and please move to the last slide, I think that the main lessons of the recent history of the Hungarian Constitutional Courts are these. First, I believe that this case shows that institutional and procedural guarantees of judicial independence in a way have great influence. But second, these safeguards themselves are not sufficient, as the Hungarian example shows, are not sufficient to defend the rule of law and constitutional democracy, but I believe supportive constitutional culture must be built up to back up the constitutional democracy. And lastly, the function of these guarantees is to protect the independence of the judiciary, of course. Once courts are subordinated to political will, they no longer have any particular value because they can become empty institutions, empty and useless procedures designed only to mask the subordination of the courts. Thank you for your attention.
Thank you, Professor, for making it less than 15 minutes, although close to 15 minutes. So the next it is quite a challenge for me because I only given 10 minutes, and while I have 3 respondents, but I believe that all the respondents can see the time counter themselves. But I would like to collect all the 3 respondents first before letting Professor Servanto respond. Thank you. So our first respondent, I will give the time to Dr. Monica.
Okay. Well, first of all, Professor Sente, congratulations on your insightful presentation and paper. I do believe like your research is quite pertinent based on the democracy challenges that the world is currently experiencing. And this brings me back to the 2023 recent index issued by the Economist Intelligence Unit, which has reported the crisis of democracy worldwide. And in 2021, for example, the index reported that there were 59 authoritarian governments and only 21 solid democracies around the world. And I also would like to share with you, because of course your presentation reminded me of some commentaries expressed during the second Democracy Summit. Samantha Power, who's the current administrator of the USAID, explained that how democratic nations are generally meeting in international forums like the one that we are sharing today, in terms of exchanging lessons learned and best practices about how to consolidate democracy, the rule of law, and the protection of human rights. But she also explained how authoritarian and repressive leaders are also sharing good practices and copying and pasting restrictive laws from one country to another in order to limit civil society organizations and to restrict the exercise of fundamental freedoms. But she also underlined how these leaders are learning from each other about how to spread propaganda and misinformation, but for example, how they are using similar techniques to dismantle institutions where democracy and the rule of law flourish, including the judiciary. And I think your paper is a quite relevant account on the different challenges that Hungary is experiencing in terms of judicial independence. And it's very well documented how the Hungarian government has been utilized by other autocrats in Europe and in Latin America to dismantle democratic institutions. And in your paper, you argue that the judicial capture has been a process that lasted several years in your country. And I wonder if you could please elaborate further on this idea, because I believe, like, in addition to the political context that you well describe in your research, I would like to know what other conditions or variables allow the dismantling of the justice system in Hungary. But also, I would like to learn more about how the general safeguards of judicial independence were established prior to these political attacks, and perhaps to learn more about your thoughts about whether judicial independence was institutionalized enough to withstand this kind of political attacks in Hungary. Thank you very much.
Thank you. So I will collect the question, the response first. Dr. Mary?
Thank you so much for the opportunity. Well, I would like to congratulate your insightful paper today, Professor Zoltan. Well, first of all, I would like to highlight in your paper, it is mentioned that the Hungarian Constitutional Court employs methods that support the government wills. Well, I wonder, probably it's going to be essential to explore the ethical implications of a constitutional court aligning with the government goals, particularly in terms of the court's role as a protector of rule of law. And then by focusing on the changing dynamics within a subordinate constitutional court and its jurisprudence due to court packing itself, I think your paper has provided a very unique lens through which to understand the intricate interplay between politics and judiciary. Well, ultimately, your paper has potential to make a significant scholarly contributions by shedding light on the nuanced aspects of Hungary's political and legal aspects and legal landscape, of course. And then about the findings of your paper itself, I think it could resonate beyond Hungary's borders, offering some lessons and insights for countries which grapple with similar challenges to their democratic institutions. Indonesian is also one of them, actually. As a case study in the intersections of law and politics, it has the opportunity to deepen our understanding of how court packing could impact the functioning of a subordinate constitutional court, enriching the ongoing discourse on the judicial independence and democratic governance. Because actually, the first time I read your article, I didn't have any idea
on what court packing is, but then after deep research, it has been used even since 1937 by President Roosevelt in the United States of America when the Congress there opposed the term of court packing to make some dynamic changes of the role of the Supreme Court in America. So it is me that is a little bit narrow-minded. One last question, actually, I am very curious about how many cases does the court have in average in a year. I'd like to know more about that because Indonesia, the Constitutional Court of Indonesia has in average around 100 until 125 cases for judicial review in a year. Then how is it in Hungary? Thank you.
Okay. Our next respondent, Ms. Titis, please make it short.
Yeah. Okay, thank you. The situation that you have described on your paper regarding the threat toward the Constitutional Court of Hungary is very relevant to the current situation in Indonesia, as already mentioned yesterday by Professor Jimli Asidiki, and also probably in other countries. It is because there are tendencies that political power will use their lawmaking powers for their interests, including incapacitating the court's power. However, in Indonesia, there are some situations where the Constitutional Court can use its judicial review power to protect the court itself, because the court can adjudicate the judicial review regarding the law of the court or Constitutional Court law. My questions are, first, are there any situation in Hungary where the Constitutional Court are allowed to adjudicate matters regarding its own powers? And second, based on your paper, one of problem arises due to the amendment of the Constitution. Are there any unamendable norm or principle in the Constitution of Hungary that cannot be changed in order to protect the ideology or characteristic of the constitutional supremacy in Hungary? Thank you.
Okay, Professor, you have 2 minutes to answer. Okay.
Thank you. So thank you for these questions. I believe so many questions have been raised that it's simply impossible to
make it quick because we have time to get the time counter.
Okay, so let me combine all these questions and to be as short as possible. So first of all, I must say that at the very beginning, I was so surprised at how much attention is paid to Hungary, because Hungary is so small a country. But I believe, and I started to understand the reason for this international attention. I believe myself, I think that there are several different reasons why the Hungarian case deserves international attention. First, I believe that the major threat of Hungarian case, that is the court packing and its consequences, is that this example can be followed by other countries too. For example, Poland is a good example for that. So, and Poland is much 4 times greater than Hungary. And it seems to me that there are followers of this populist transition or authoritarian transition even in the European Union, and as I referred to in my presentation. Second, I believe that it deserves attention, or it is worth studying this case, the whole process of court packing. Somebody referred to the Roosevelt. That was only a threat of court packing. Hungary has accomplished, so that is a fully fledged packed court. Frequently the U.S. Supreme Court is characterized by the ratio between the conservative and liberal justices. That may be 7-2 or I don't know, 6-3 at the moment. In Hungary, there is a very clear picture because we have a ratio between the pro-government and opposition judges 15-0, you know. And yes, and finally, only one remark. You know, Hungary was, before 2010, a fully fledged constitutional democracy. It was a pattern of modern democracy. As a post-communist country, it was a champion of democratization process. But I would say, and if I can say only one reason for the whole dismantling of the rule of law is the two-thirds majority of a populistic, nationalistic populistic party, I think that the two-thirds majority, that is the constitution-making majority of the governing parties, simply executed the whole system of constitutional guarantees. Yeah, sorry.
Okay, I believe the discussion can be continued outside this later on. So we move to the online Zoom questions from Wiranto. What form and mechanism of regulation does it also regulate the indicator? Indicator, maybe you in your slide, in your strategies. Maybe
no. Maybe it might be a misunderstanding. So I was talking about my own analytical framework.
Oh, okay.
You know, so these are not legal regulated indicators.
Okay.
Of the court packing.
Okay. Okay. So I open only one from the audience in this. Yes, Professor Lindsay. Just I'm sorry, but make it quick.
I'm really interested in your comment about the need for a supportive constitutional culture as a way of trying to prevent these developments from happening. And how would that be done, is my question. How can a supportive constitutional culture be developed? Presumably that takes a very long time and a lot of different subtle mechanisms to achieve, but I'm interested in your thoughts.
Thank you. It's not an easy question anyway. There was a very long period of time with communism for 40 years, before 1990. After that, there was a transition to democracy. That was a very quick process, transition process for 1 or 1.5 years. After that, Hungary was a model democracy, let's say, for 20 years, between 1990 and 2010. It seems to me that these 20 years were not enough for deeply entrenched constitutional culture. The main reason, and I don't have, enough time to settle my opinion, but I believe that this modern democracy which was established in Hungary after 1990 was an elitist democracy. You know, constitutional court very far from ordinary people. They're dealing with very complicated legal constitutional disputes, not on the day-by-day problems. The court failed to do so. So that was an elitist democracy. And as a result, the populists had very easy job to turn back the whole process. So shortly, that's
Okay, I think because we ran out of time, I think for further discussion, it can be discussed after the session. Okay, let us give applause to this session. Thank you so much, Professor. Thank you so much, Dr. Monica, and thank you, Dr. Mary and Ms. Titi. Okay, we move to our next speaker, the last but not least speaker in this session. May I call Dr. Idus Risan to come front, and also the respondent, Mr. Justin B. Pearson from William and Mary Law School, the United States of America. Okay, online. Are you there? Excuse me.
Hi.
Yeah.
Yes, I'm here. I can't turn on my video, but I'm here.
Okay. And second respondent, Mr. Abdul Basit Fuadi from Indonesian Constitutional Court. So, Dr. Idus Risan is from Universitas Islam Indonesia. He will speak about the rise and fall of constitutional court, comparative court packing in Hungary, Poland, and Indonesia. As like our rules in this conference, 15 minutes for the, okay, time is yours, Dr. Idus. I'm sorry because this is Friday. Since this is Friday, we have to have Friday prayer. So the further discussion can be do later on. Okay, Dr. Idus.
Okay, Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. The Honorable Host Bu Diana and beloved speakers and respondents. I would like present my papers. My topic for this event is the rise and fall of constitutional court, comparative court packing in Hungary, Poland, and also Indonesians. Next slide, please. Okay, ladies and gentlemen, to begin with, let me explain why I'm concerned about the issues in Hungary, Poland, and Indonesia. In my point of view, among these countries have a similar growth regards the rule of law and democracy, but the bad news, I mean, in the last 10 years, each of these countries has run into democratic regressions. We could refer to the current studies such as Professor Halmay and Kim Lane's, the Hungary illiberal turn disabling the constitutions, also proposed or provides by Professor Sadurski, How Democracy Die in Poland, a case study of anti-constitutional populists, and also the recent issues proposed our professor in Indonesian, Professor Jimli Asidiki, democratic regressions and the rule of law in Indonesians. Next slide, please. In addition, to limit this comparative study, I will divide the explanations into two parts. The rise, I mean, for the issues the rise, I'm going to share comparisons of the history, also the powers, and also the last one, the impacts. And the section of the fall of constitutional courts, I used the approach proposed by Dixon and Landau, 2021, that describe the element of court packing, such as decreasing or increasing the number of judges in their panels. Second one is dismissing judges during their term of offices for political reasons, changing the retirement of age, and also politicizing judicial appointments, and the last ones, taking the disciplinary measures through the administrative sanctions. But my research today only emphasizes the court packing events. Landau and also Dixon describe two models of undermining judicial independence. That's we call, the first one is court packing, and the second was in court crabbing. So my research just only focus on the court packing in Hungarian, Poland, and also Indonesians. Next slide, please. So, okay, this is the rise. Why I say this is the rise of constitutional court in Hungary, Poland, and Indonesians? Because among these countries have a very similar growth from the strong constitutional courts in the first decade after the establishment. So my research provides among these countries, I mean, have a similar symptoms regarding their establishment. I mean, the shifting political configurations, post-communism in Central Europe and post-authoritarianisms in Asia are the main cause of establishment of constitutional courts. So, and among these countries, each country shows the different roles and authority because, I mean, I found also the study provides that response to previous regimes, encourage the kind of role constitutional courts, such as constitutions drafting, judicial review, jurisdictions over official agencies, and jurisdictions over parties' elections. So the interesting fact, the 1 decade after their establishments, the Constitutional Court has strategic roles in the development of law in each country. In Hungary and Poland, they called courtocracy, when Constitutional Court in the first decades always delivers or provides a positive legislators to adapt the communist law into the democratic law. That is very similar in Constitutional Court in Indonesia under the Professor Jimli Asyidiki and Muhammad Mahfud. That the Constitutional Court in the first decade, in the first 10 years, always delivers the substantive justice in the case of elections, in the case of criminal law also. So that's why the studies provides the rise of Constitutional Court in the Middle Europe and also Asia, because they have a similar symptoms and patterns. So this is the comparisons of Constitutional Code. Its roles divided into constitutions drafting, judicial review, official agencies, and party elections. The membership in Hungarian Constitutional Court comprises 15 judges after the constitutional amendment in 2011, because before constitutional amendments, Hungarian Constitutional Court comprises 11 judges. Next slide, please. Okay. So in Constitutional Tribunal in Poland also comprises 15 judges, and Constitutional Court in Indonesia comprises 9 judges. Regarding the appointments, if we compare among this country, Hungarian Constitutional Court appoints by the legislative branch, and the Constitutional Tribunal also appoints by the legislative branch. But in Indonesians, we propose the model split and quota in Indonesians that proposed by the executive branch, like a president, proposed by the DPR, our house, and also proposed by the Supreme Court. Regarding the term of offices, Hungarian Constitutional Court provide 12 years might not be re-elected. This is grants in the Constitutional Court Hungarian law. Also in Constitutional Tribunal, 9 years might not be re-elected. Constitutional Court in Indonesians not more than 15 years based the existing law. As we know, Constitutional Court, before the amendments, the law of Constitutional Court in 2020, the term of offices every judges provide 5 years, and subsequently re-elected for 5 years, so maximize 10 years. And after revisions, maximize 10 years old and no more than 15 years. Next slide, please. So this is the phenomena of the fall of constitutional courts in Hungary, also Poland and Indonesians. In Hungary, after the Viktor Orban's, winning the consecutive elections, Fidesz party changed rules on appointing Hungarian Constitutional Court judges. If we compare with the previous appointment of Constitutional Court justice in Hungary, proposed or nominated by the Specials Committee, but after the constitutional amendments in Hungary, the Constitutional Court justice appoint or nominate by the majority vote in parliaments. The second one, also the constitutional change in Hungary, changed the composition of judges by increasing the number of constitutional judges from 11 to 15. And also in the law of Constitutional Court in Hungary, limits the role of ICCIS through the amending the law in regard tax and budgeting in judicial review case. In Poland, the case in Poland very similar with the case Marbury versus Medicines in the United States that calls midnight appointments, but in Poland they called like October judges when the 5 candidate judges elected by the previous regime after that denied by the winning party, Law and Justice Party, and delegitimized 5 constitutional judges based on the old candidate and proposed the 5 new constitutional judges in Poland. Also in Poland, there are big issues because if we compare with the law of Constitutional Tribunal before the amendments, the Chief of Justice Constitutional Court, it should be elected by their members after the revisions of Constitutional Tribunal law. The Chief of Justice appoints by President of Poland. In Indonesia also happened court packing, in early 2020. President amends the law of constitutional courts to change the minimum age requirement and tenure of constitutional justice. This has become a big issue because the transitional provisions enforce to the existing judges, especially to extend their tenures, but excludes the minimum age requirements. So the second issue is what Professor Jimli Asidiki said. We do hope this is never happened again in the history of constitutional courts. A very abusive removal of Justice Swanto from the constitutional court and propose the new candidate by House of Representatives. The last issues in Indonesians also proposed the draft of 4th amendment of law of constitutional court that we now political party in the House will have a high chance to evaluate the tenure of constitutional judges every 5 years. So this is my focal point of my research, comparative court packing analysis. If we compare Hungarian's constitutional tribunal and constitutional court, both of Hungarian constitutional court and constitutional tribunal changing the composition of judges and also dismissing judges with no ethical and legal process. That's happened in constitutional court Indonesians because without legal ethic process, and also changing term of offices. That's also happened in Indonesians. And the last one is politicizing judicial appointment happened in ICCIS city and also constitutional court. So as we can see, the cause of court packing, I provide that because the emergence of populist leaders, because populist leaders, try always eliminate the opposition's movements. Yeah, the subject is political party and also governments. The procedures can happen with 3 ways: abusive lawmaking, abusive constitutional making, abusive policy. The moments that I found, in the early of government after the announcement of elections and the midterms of governments before the elections. And the goals is the frequently used by regimes to appoint loyal judges are those having the same political preference. The main goals, the last goals, controls the judicial interpretations. So my study also provides, this is from strong constitutional courts to fragile. So the constitutional court should be designed to limit the role of political parties and the governments. But in regression conditions, as we can see, the constitutional courts become very dependent on political party. That's my all presentations that I have shared to the all respondents. Thank you so much.
Okay, thank you so much, Dr. Idul. Now we move to Justice. Can you hear me? Justin.
Hello.
Justin, can you hear me? Okay. Okay, you have 3 minutes to deliver your response. So it will give Mr. Dr. Idul to comment on your response for 2 minutes. So you have 3 minutes starting now.
Hey.
Thank you.
Thank you. Yes, thank you, Dr. Idul, for your presentation. I thought it was a very useful and helpful comparison. And we've had, court packing and court crubbing have been major conversations in the United States too. And often legislatures will style interventions in the judiciary as reforms aimed at improving accountability and public trust. So I was wondering if you kind of encountered that in your research, if that's something you've observed. And the secondary to that is how you would kind of evaluate the role and when it's appropriate for the other branches to involve themselves in judicial reform. And if there's a clear standard for when you would call something court crubbing or court packing as opposed to when something is a legitimately aimed and targeted judicial reform that appropriately involves the other branches. So because for context, kind of in the United States, like our Senate has been involved in a conversation about whether the Supreme Court should enact a ethical code, because our Supreme Court does not currently have a written formal ethical code. There is one that's applicable to the district judges in the federal courts that beneath them, but our Supreme Court does not have one, and our Senate has been having a conversation about whether they can force one on them, essentially. And court packing has long been a conversation, and we have life tenure in the United States. There have been conversations about whether we should have a mandatory retirement age, or if we could have some kind of staggered system for selection of judges. But partially that would be to achieve a political or ideological balance on the court, but also in most of the states, there's different systems of tenure. So a lot of states will have a mandatory retirement age, and part of the justification for that would be as judges age, they have health issues and could face senility, and they might become disqualified. And is there a way to remove justices who are no longer qualified to perform the role that has been given to them? So I'm wondering, I guess, how you would draw that boundary when it's appropriate for the other branches to be involved in judicial reform, when something is court packing and court crubbing, as opposed to something that might be legitimate. And thank you.
Okay, thank you. Dr. Idul?
Okay, thank you, Justin, for the comment of my research. So, in begin with, Justin proposed the questions how to evaluate or to prevent the constitutional code from abusive of court packings. So, I mean, for the first ones, every country, I mean, they don't have a similar standard when, for example, the age requirement, for examples, the term of offices, when we have to grant with the constitutions and when we have to grant or ensure with the law. So for examples in Indonesians, as we can see in Indonesians, the all relations, the all arrangements regards the judicial appointment procedures and also term of offices grants by the law. So this is how to making the court packings become the soft approach. I mean, so we can use, I mean, like transitional provisions that we means every change that related about tenure and also the composition of justice, we must ensure that enforce or binding for the next justice, not to impose to the existing justice. I mean, that is for the first one. The second one is how to save the constitutional code from abusive court packings. I mean, for the first one, protections of the independence of tenure of judges in the constitutions. Even this is not always ensures giving the protections, but I say this is better because in Hungarian constitutional code, as we can see, the arrangement of judicial tenure and also the compositions granted by the constitutions is very easy interference by court packings because I mean to ensure the limitations procedure of amendment. This becomes the important thing toward the clause of appointment or dismissal and tenure of judges. For examples, in the constitutions, we can maintain the flexibility and rigidity in our constitution that all clauses related, for example, judicial independence, we can provide the certain procedures, not only based on majority votes in parliaments, because we know in democratic populisms, the parliaments mostly supports the governments now, and how to making as much as possible the coalitions, political party and parliaments, and eliminates the opposition's movements.
Thank you. We move to the second respondent, Mr. Fuad.
Thank you, Bu Diana. Thank you, the chair. Honestly, I'm a bit nervous because Pak Idol was my lecturer when I was master student at UII. So for the first, I would like to congratulate and appreciate. It provides very valuable knowledge for the participant, especially for me. I broadly agree with what you have written. Court packing is the act of tinkering the composition of judges in the court to influence the ideology of the court. However, I would like us to consider something else. Court packing is a complex issue and there is no easy answer. It is important to consider the potential consequences of court packing before deciding whether it is appropriate or not. As a pluralistic country, Indonesia made up various interest groups. My question is, does the Constitutional Court need to be filled with a certain composition that represent various elements? For example, by consideration about women representative or Muslim or non-Muslim, and etc. From an Indonesian perspective, court packing can be seen as a threat to threat to pluralism because it gives one group or ideology more power. But court packing can be seen as prevent pluralism. I base my response for public discussion when Maria Farida and the Trump. The discussion, public discussion, indicate that there should be another female justice to replace Maria Farida. And the president showed the intention to remove Maria Farida and replace with another female justice. I hope to hear your response.
Okay, thank you, Mas Fuad. So for the first ones, I consider to tell all participants actually court packing used by two conditions, with the best practice of court packings and the bad practice of court packing. For the best practice of court packings always provided by David Cousars when the court packing used in the early of political transition shiftings, from, for example, authoritarian and also to the democratic transitions. But in fact, this is also happened when the democratic is being stable. So the court packing in the democratic being stable, the populist leaders or the populist movements try to interfere the judiciary with the court packing technique, like changing the composition of justice, for example, increase the number of justice, for example, politicizing the judicial appointments. For what? I mean, based our research, this is to compromise with the judicial, with the interest, with the very interesting case in, for example, in Hungary, Poland, and also Indonesians, because the court packing recently used to appoint loyal judges of those having the same political preference as the governments. I mean, the last goal is how to control the judicial interpretations from strong judicial interpretations become a very weak judicial interpretations caused by the court packing. So the second response about the representative members in constitutional court, I think this excludes the conceptual dimensions of court packing. So if we are concerned about the representative members in constitutional court, we can use like the international guidelines, like the balance of gender, something like that. That also happens in Indonesians. There is no written law in Indonesians that female justice have to replace by the female justice, but the international conventions, the constitutional court must represent by the, non-partisan members, from female and also male members. That's all my response.
Okay, thank you, Dr. Idul. Now we move to the question and answer. Since there is no questions online, I would like to ask audience in this room whether is there any questions. I would like to have one question. Okay, two questions. Okay, first, Pak Frit, we will collect the questions first, and then Dr. Idul will answer. Thank you.
Thank you, Ibu Diana. So I want to comment the last statement from Idul, that the court packing is, if I'm not mistaken, read your statement that the court packing is okay after or when the democratic, I think, is still in transitions. Yeah. But when democratic is already stable, the court packing is become a bad one. Yeah. So I think should be, what if my statement is, when the court in the early democracies, the court may produce more substantive justice. Yeah. But we knew substantive justice is against the current law, changing the stability of the law because the court become the positive legislator. Yeah. But when the democratic is already stable, the court also must behave. I mean, we cannot say that the parliament is wrong if they attack the court because the court doesn't respect its authority. If the court is only say, yes, the court has judiciary review decisions, but when the democratic is already stable, the court also has responsible to restrain himself, not to issue any decisions that may harm the democracies. Yeah. Because there is also possibility that the main problem is not the parliament, but the court is the one that has bring the problem. What is your response about it? Thank you.
Okay, thank you. And we move to Mirza. Please make it quick.
Thank you so much, Mas Idul. It was a very insightful presentation. The comparative notes are very high standard, I think. I congratulate for that. But, you know, from your description, it is I can conclude that there are inevitable relationship between court packing and the dominant party coalition, especially Indonesia. Yeah. So, like as David Landau said, that everything depends on the dominant party coalition, whether it is in Latin America or Eastern European and also in Indonesia. So we share the same problem, populism. Yeah, our citizens are very easy to fall in love with the leadership, you know, with the charisma, something like that. So my question is, based on your conclusion, how to save constitutional court, three of them, I think, is very dependent to legislative. Yeah. So I think it is good, but it's quite, how to say it, naive, you know, because at the end of the day, we will dependent to the dominant party coalition as well. Yeah. Is there any strategies to strengthen our judiciary? But not by using that kind of way, you know, the legislative way. Maybe from the, you know, like Landau said, maybe there are external supporters of the court. Do you see that in Indonesia? Maybe that movement. I think that's all. Thank you so much.
Thank you so much. Very difficult questions. I mean, from Pak Fritz and also Professor Mirza Satria Buana. In begin with, I would like response Pak Fritz's questions that I would say like in the beginning of political transition, some courts involved so many corruptions, for examples, that the governments in political transitions do the court packing to save or to reshuffle the judges in political transitions to emphasize the stable governments. That's always do by the early of political transitions, because from the authoritarians to the democratic. So how to save that? Sometimes the leaders in political transitions try to minimize, increase, decrease, or politicizing judicial appointments. So and in the stable democratic governments, this is very forbidden to do by the courts. I mean, we cannot pure deny that, Fritz, but we can mitigate. What kind of efforts to mitigate that? We said in the transitional provisions. Sometimes, if they have to say it in the in law, or that is open legal policy, so we have to enforce for the next justice, not to enforce to the existing justice, because it's very dangerous. Because the international standards provides that the judicial independence must must protect the tenure of justice during his term of offices. So don't try to do the court packing to the existing justice. If we have to do the court packing, so we have to set in the professional transitions to the future justice. I mean, for the second one, I do realize, Professor Miza, it's too difficult, or I said, it's too impossible to separate the role of political party with the constitutional courts. Yeah. So as we can see, we cannot separate, pure separates, but just only I consider to mitigate. How to mitigate that? So that's why we involved independent agencies to minimize the role of political party, for example, in judicial appointments, like in constitutional court. So we can use like independent agencies to minimize the interference from or the influence of political party when they try to choose or nominate the candidate in constitutional courts. That's all my response, Professor Miza. Thank you so much.
Thank you so much. So it is, if I can summarize from this discussion, it is argued that political and social interference with regard to whether judgment of the court packing is always exists to the system of constitutional court, and most of it based on the cultural aspect of the state itself. So we come to the end of this session. Thank you very much for 3 speakers. And let us applause for the last speaker. Thank you so much, and we managed to finish on time. I will return the time to the MC.
Thank you. Such an insightful discussion to start the second day of the 6th ICCIS 2023. Let's sending big applause for the chairs, speakers, and respondents for the 3rd sessions. And now, ladies and gentlemen, I would like to invite Dr. Heribertus Jakatriana from Faculty of Law, Gadjah Mada University, as the chair of session 4, with sub-theme Constitutional Court's Budget and Financial Independence. We have 3 speakers as well as this session: Ms. Monica Castillejos Aragon, Mr. Fritz Edward Siregar, Ms. Cekli Setia Pratiwi. So, Mr. Chairman, the time is yours.
Thank you very much, Mrs. Moderators. Ladies and gentlemen, now we may start for the 4th sessions from this conference. First of all, may I greet you, selamat pagi. Semua pada lemes. So, I will start with pantun, you know. Ikan sepat, ikan gabus, makan ikan lele ditangkap oleh jurgen klop. Cakep gitu dong. Ulangi, ikan sepat, ikan gabus, ikan lele ditangkap oleh Jurgen Klopp. Semakin cepat, semakin bagus, saya nggak usah bertele-tele sehingga saya cepat dapat amplop. So in English, Monica, it is called sooner is better. Yeah. So ladies and gentlemen, we will have sessions from Dr. Monica Castillejo Arajon from University of Berkeley, United States, that she will present the populist capitulations of populist movement, the Mexican judiciary under scrutiny. They will be responded by Professor Sang Yun John. Annyeonghaseyo, Professor.
Oh, hello, good morning. Yeah, I'm in Seoul, so I'm online.
Yeah, thank you very much. And then the second respondent will be Pak Zaka Firma Aditya from Indonesian Constitutional Court, as well as Ibu Rizky Syahbana Yulistia Putri. Good morning. So the first, we will welcome Dr. Monica to present her presentations entitled, as I mentioned before, so por favor presente su trabajo. El piso es tuyo for máximo 15 minutos. Gracias.
Muchas gracias por su presentación. Muy buen español. Well, first of all, I would like to begin this presentation by thanking the members of the Constitutional Court of Indonesia for the invitation to participate in this very important conference with such distinguished scholars and colleagues. It's truly a pleasure to be here today. So, liberalism has been challenged in recent years in Mexico. Under false pretenses of governmental austerity, the political establishment has been using its electoral mandate to undermine liberal institutions in Mexico. And these are institutions that are considered essential pillars to democracy in this country. And unfortunately, the Mexican judiciary hasn't been immune to such overreaching influence. And over the past years, on multiple occasions and fronts, the bench has been under attack by political elites, leading judges to concede a great portion of the judiciary's independence, as well as its long-standing process of judicial transformation, renovation, and progress. So let me provide some political background and historical context about the ongoing situation in Mexico for you understand better the political context that Mexico is experiencing over the past 5 years. On two specific historical phases, the Mexican judicial branch has been under assault and reduced to a subservient role by political regimes in the 20th and 21st century. During the period from 1929 to 2000, Mexico experienced a system where the government's executive branch was powerful enough to subordinate the legislative and judicial powers. In theory, the separation of powers was recognized in the Mexican Constitution, and also it was recognized by the Institutional Revolutionary Party, or the PRI, as leading tenet of defining the Mexican governmental structure. However, in practice, the president was dominant and limited the powers of the other branches of governments through the adoption of hundreds of constitutional reforms throughout the history of Mexico's constitutionalism. And these reforms were effectively because they restricted the institutional capacity of the Mexican Supreme Court to properly function as arbiter between the presidential and congressional authorities, but also they limited the capacity of the Supreme Court to actually protect effectively the fundamental rights of Mexican people. So during the PRI regime, the court system served as a preserver of the authoritarian rule, and the Mexican Supreme Court became a passive and unimportant institution during 70 years. Judges simply aligned themselves to avoid any kind of confrontation with the executive power, and the judiciary also responded to the wishes to the executive as expressed through a number of formal pressures and incentives ranging from political loyalties and political rewards and career incentives. And there is extensive scholarly research that has documented the passive and limited role that the Mexican Supreme Court played in deciding widespread fundamental rights violations during the PRI regime. Next. So Mexico's judicial inadequacies were seen as product of different shortcomings, including the lack of judicial independence, thousands of inconsequential cases, high levels of corruption, and of course, ill-trained public officials, including judges, for them to be able to issue substantial and legally grounded judicial opinions during the PRI regime. But these inadequacies also set the stage for multiple human rights violations during the 7 decades of the authoritarian rule. And in most of the cases, human rights violations were condoned and suppressed by the authorities who were responsible for prosecuting and investigating these events. However, as I described in other research, following Mexico's democratic transition in the mid-90s, next, from 1995 to 2018, next, please. I think it has, okay. The Mexican Supreme Court initiated a fascinating process of judicial transformation, which positioned justices to develop novel fundamental rights agenda in Mexico. And since 2004, the court often has been viewed not only as a forum to settle disputes, but also as an instrument of social change. The Supreme Court, for example, issued decisions that were unthinkable during the past authoritarian rule, such as the interpretation of women's rights, indigenous rights, freedom of expression, press and association, privacy rights, and the access to governmental information, among many other human rights recognized in any democratic society. Next. So what accounts for that change? In previous research, I also described how the 1994 judicial reform, Mexico's new competitive political party system that emerged in the year of 2000, and the role of progressive justices allow for the Supreme Court to transform itself into an arena for political contestation. And since that year, the court became more assertive and independent branch of government, and it gradually regained its autonomy and independence from the past authoritarian rule. So how was the Mexican Supreme Court able to increase the human rights agenda in Mexico? Next. From 1995 to 2010, the Supreme Court focused on producing synergies among different actors, including members of the legislative power, also with the executive power, but also with members of mass media, the legal profession, civil society organizations, and interest groups. And only when all these synergies work in tandem with the Supreme Court, the number of fundamental rights cases in Mexico spiked dramatically since 2007. Next. And as judicial impact literature shows, courts alone hardly can do much to advance social or progressive social agendas, and perhaps the Mexican Supreme Court provides a clear example of this, because over the whole history of the Mexican Supreme Court, justice did very little to embrace their constitutional mandate until these new synergies were developed in the country. However, the process of institutional and judicial transformation was clearly disrupted in Mexico. Next, in the aftermath of the 2018 presidential election, the current president of Mexico, Andrés Manuel López Obrador, announced the implementation of the so-called austerity plan and unveiled a campaign against the legitimacy of Mexico's democratic institutions with a special emphasis on the judicial branch. And as soon as he took office as a president of Mexico, he publicly advocated to constrain the judicial branch and announced early signs of political threats and drastic actions against the judiciary. Next. First, for example, the executive suggested the replacement of the Mexican Supreme Court for a constitutional tribunal. And this change would reduce the function of the Supreme Court to a mere court of appeals, and it would also set the stage for the president to remove the current membership and to appoint judges close to his political ideology. Second, the executive attempted to dismantle the Federal Judicial Council, which is an instance of the federal judicial power created back in 1994 to oversee the judicial administration and to foster the independence of the judiciary. And his administration also sought to establish new patterns for the judicial career with the purpose of revising the opposition exams to carefully select those officials aspiring to serve as district judges or federal magistrates in Mexico. And based on these early signs of political research, in 2018, the process of institutional strengthening, as I'm showing in this research, was disrupted. Over the past 5 years, the Mexican judiciary has been under attack, and the Mexican judges are in the front line. But I also would like to emphasize that since 2018, justices have been threatened by political power grabs coming from an overwhelming majority of members of the political party of the president, similarly of what we just saw in Hungary and in the case of El Salvador. And by looking at the political trajectory of the president of Mexico, one perhaps could develop new insights not only about the enabling conditions for such political intervention over democratic institutions, but also our understanding of the rise and consolidation of an interbranch populist government in Mexico. And I would like to underline this morning that this is the second major assault against the judiciary in our entire constitutional history. Next. Contemporary discussions on world politics examine the emergence of governments characterized as populist and utilize several approaches to explain this political phenomenon. Surprisingly, during my research and despite the growing trend of attacks of populist governments against the judicial independence in the 21st century, there is very little research that examines the role of courts in such escalating and influential political traditions beyond the well-known cases of Venezuela, Bolivia, and Ecuador. And recent research also, based on the so-called judicial populism, has emerged to examine how judgments and judicial practices are propelled by the masses on certain perceptions of justice. Next. And in this paper, basically, I'm just trying to contribute to the judicial populism scholarship, and it also provides an account of what is the process and enabling conditions under which political influence may take place, and what are the conditions that have facilitated those attacks against judiciaries under populist governments, and using specifically the Mexican case. But also this paper answers broader questions on how courts repeal those attacks and what are the legal responses to populism and when and how judges capitulate over populist discourse, if ever. And perhaps based on the recent developments, the Mexican case presents one of the most contemporary cases in the region of an emergency of populist government and its general implications over the independence of the judiciary. And to be mindful of my time, I will stop now and maybe I can elaborate further additional ideas during the discussion. Thank you very much.
Muchas gracias, Senora Monica. It is a very precise time. And ladies and gentlemen, for the first respondent, may I invite Professor Sang Yoon Jeon from Seoul National University, South Korea, to make a comment and also, if it is possible, questions to Dr. Monica. Professor Sang?
Yeah. Can you hear me?
Yeah.
Yes.
Loud and clear, Prof.
Yeah. First, I appreciate your interesting and informative presentation. Your detailed description is very helpful to understand the situation in Mexico. So I have two or three questions about your presentation. Actually, I read your full paper, and I had some questions about in Mexican situation. The first one is that what's the reaction of the people about the uh, reformation or innovation, so-called, but you criticize as populistic reformation of the court. So I think the judicial branch is the weakest branch in the government. So they only depend on the people's agreement or people's trust, I think. So my first question is, what's the reaction of the people in Mexico? And the second one is, as you explained, the Senate approved all the new justices with overwhelmingly approval. I wonder what the situation is going on, because as you criticized, if the reformation is so very bad for judicial independence, then why the senators approved so supermajority, so overwhelmingly the newly appointed justices? That is my second question. The last one is that I'd like to clarify first the fact of the institutional reformation. So do you have a new constitutional tribunal or a plan to establish a constitutional tribunal? It's just a question about fact. But my question is, what's your opinion about establishing a separate institution for constitutional adjudication, such as constitutional tribunal or constitutional court? Because as long as I know, in Mexico, you have the similar system as U.S. System. But if there is no trust about the justices of the Supreme Court, then I think you need to think about establishing a new constitutional institution, constitutional tribunal for constitutional adjudication. Yeah, I think. Yeah, that's my question. Thank you.
Thank you, Professor Shang. May I invite Pak Zaka Firma and then Ibu Rizky, and finally, Monica, please give your response, please.
Okay, thank you, Mr. Chairman, and Dr. Monica, congratulations on your insightful paper. The paper is well researched and well argued analysis of the challenge facing the Mexican judiciary in the face of populist power. It provides a clear and concise overview of the concept of populism, and it discusses the specific way in which populist leaders have sought to undermine the independence of the judiciary in Mexico. I believe that Mexican judiciary is not the only country facing the forces of populism. Other countries also facing similar challenges. I have some question about your paper. Could you explain first how has the Mexican judiciary respond to this challenge? And second, what lesson can other countries learn from the Mexican experience? And the last one is how to take back the judiciary from the current political control. I thank you.
Thank you, Pak Zaka. 3 questions, so it means it's already 6 questions, Monica. Wonderful. Yeah. Bu Rizky.
Thank you, Pak Jaka, and hello, Dr. Monica. I hope you enjoy your time in Jakarta. And I would like to say thank you to the committee who give me the opportunity to sit here with all these amazing speakers, chair, and also the respondent. Dr. Monica, congratulations on your very insightful yet amazing paper. Capitulation to populist power, your paper, really a good reading material for me. I really enjoy the way you tell us as a reader, especially for me, about the populist movement in Mexico. I mean, first you tell us about in the beginning you write about the judicial populism in general, and then you tell us about the assault in Mexico on the Mexican judiciary during 1929 and until the 20s, yes, okay. And after that, you give us the real story about what happened in Mexico since the 20 and 18. Yes. The consecutive timeline really helps me to understand what really happened in Mexico during that time, so thank you. I really like it. And I think you're really brave for using the term, the decay of judicial independence in your paper, because if I read a paper, I'm not brave as you maybe. Thank you, I really enjoy your paper. Dr. Monica, I really want to know about your opinion about the salary diminution, because you write it right on your paper. If I'm not mistaken, it states on 9 page or 9 until 12 page of your paper, right? So, in your opinion, how far the high salary of the judges or judiciary employee can guarantee the judicial independence? And then, in your opinion, who will be the best party or the best organ to determine the budget of the judiciary to guarantee their independence and to reduce the trends maybe from the populists? And could you explain more what really happened in Mexico about that one, about the budget of the judiciary? Thank you, Dr. Monica.
Thank you, all the respondents. So, Dr. Monica, you only have approximately 2 minutes to respond to 9 questions. Make it quick, make it simple, and it's up to you.
I will try my very best. In terms of the reaction of people, I think like we are in Mexico experience a great difference of what we experienced during the authoritarian rule in Mexico. Fortunately, the Mexican civil society has been very actively resisting these political attacks, and I think that can be considered a very sign of hope in order to keep preserving the independence of the judiciary. Professor, you also talk about whether people have approved the new 4 appointments of justices out of the 11 that we have at the Supreme Court. There has been a lot of controversy considering some of their past political backgrounds and close relationships with the president, former public service. So to respond your question, there has been some backlash and rejection of some of the appointments that President López Obrador made recently. You also mentioned whether Mexico needs a constitutional tribunal and if it would be ideal for the Supreme Court to be replaced by this tribunal. In my opinion, Mexico since 1994 has a constitutional tribunal. With the differences like in Latin American models, you can find like different ways to compose a constitutional tribunal in the region. You can have a separate constitutional tribunal and the Supreme Court, or as in the case of El Salvador, where within the Supreme Court there is a constitutional chamber. But in the case of Mexico, the Supreme Court has functioned since 1994 as a constitutional tribunal. So to respond your question, no, I don't think like Mexico deserves. I think this is more a political move from the president in order for him to be able to appoint new judges that are close to his political ideology. Rizkis, thank you so much for your questions as well. You are asking me how the Mexicans judges respond to these political attacks. Well, similarly to the case of Hungary, at the beginning, the Mexican justices remained completely silent. Only federal magistrates were the ones who publicly resisted and challenged these political strategies, but the Mexican justices simply didn't make any statements about the ongoing situation. However, this year in 2023, there was another sign of hope because the Mexican Supreme Court appointed the first woman Chief Justice in a history of 200 years. And she has been more vocal and defending and preserving judicial independence. And for many, that is also a very good sign of how institutionalized the principle has been entrenched in the Mexican legal framework. And finally, Saka, thank you so much for your questions. In terms of the salary remuneration, I do believe like it is important for Congress to remain with this power, but also I think it would be also important for the judiciary or some representatives of the judiciary to be part of the process, for them to be able to determine what are the needs of the judiciary, because who else can establish the needs if it's not the judges? Thank you very much.
Thank you very much, Dr. Monica. It is a very insightful comments, but there are also questions from the online participants. As you can see in the screens, why does the judiciary seems to be in the hands of God? May you rephrase to these concerns, and what are the fundamental reasons why changes to the constitution are considered to violate judicial independence? And as you can see, there are so many questions because your paper is so interesting for the participant. So please.
Could you please scroll down again?
Scroll down again, please. Thank you.
What are the fundamental reasons why changes to the Constitution are considered down?
Up, please. Yeah.
To violate the independence. Well, I think this is a very relevant question that you are posing about why these changes or these reforms like President has been advocated violate the principle of judicial independence. And I would like to share one specific example, because in 3 attempts he has tried to adopt or pass the legislative law on salaries remuneration. And this is basically against what the Mexican Constitution says, because it clearly established that justices' salaries cannot be reduced during their term in office. However, knowing that there is this constitutional provision, he has attempted 3 times in order to keep pushing for judges to reduce their salaries. In terms of your comment of the judiciary being in hands of God, I think that was one of the expressions that President López Obrador utilized when the justices voluntarily agreed to reduce 25% of their salaries as a result of the first political threat to reduce their remunerations during office. Another question?
Scroll down, please, yeah.
Is there any particular reasons to distinguish when changes to the Constitution are considered to touch independence and when they don't? Because changing the Constitution cannot, mutatis mutandis, change the soul of the Constitution itself. I completely agree with you. However, there is a really interesting part of the history of the Mexican constitutionalism, because during the PRI regime, the political party basically utilized the political or the constitutional reform in order to tarnish or undermine the operation of the Supreme Court in Mexico. However, I do believe, like President López Obrador is now utilizing more sophisticated mechanisms in terms of limiting or restricting the power of the Supreme Court justices in Mexico. Of course, he's still utilizing the constitutional reform in order to accomplish this goal. But again, he's now thinking about new strategies about how to undermine the role and operation of the Mexican Supreme Court.
Thank you, Dr. Monica. May I invite ladies and gentlemen in this forum, one question, please? No? All right, thank you very much, but I have two questions for you, Dr. Monica. It is very challenging. At the end of your paper, you just ask yourself with two provoking questions. What will you prospect and respond to your own questions in your paper?
Okay. Well, if you had asked me these questions or the set of questions on whether the judicial, the judges have actually capitulated to populist power, I would say like, yes, maybe that was a trend like we saw over the past 4 years. However, as I mentioned during my presentation, in January this year, a woman Chief Justice was appointed at the Supreme Court. And I feel like that's also a sign of hope on how the judicial independence is going to be managing in the following 2 years of the end of his administration. Maybe some of you know, like next year, Mexico is holding presidential elections, and President López Obrador is also pushing for one of his political allies to become the next president of Mexico, for them to keep furthering the political agenda that he has advocated over the past years. However, I guess many scholars and members of civil society organizations have also showed this sign of hope, because the new leadership of the court and how Chief Justice Norma Piña is leading the judiciary since January this year.
So thank you very much, and I think should be written in your final conclusions then.
I will do that. Thank you so much.
Thank you very much,
for your insights.
Dr. Monica, Professor Sang Yun Jun, Pak Zaka, and also Pak Rizky for the first sessions. And let's end this first session and try to move to the second sessions. Thank you very much. Muchas gracias, Monica.
De nada, gracias.
In Korea, thank you very much. Kamsahamnida, Professor Sang. Thank you very
so
much.
Thank you so much.
So, may we continue? May I invite Pak Frits Edward from Faculty of Law, Jentera University as the speakers. And may I invite Professor Simon Budd from Sydney University of Australia. Good day, Pak Simon. Still in Australian language. Good day. And also Pak Lutfi Ediono as the second respondent.
It's all big guy, eh?
Yeah.
All big guy.
In bahasa Indonesia, we call it gerombolan si berat.
I'm not talking about you, but I'm talking about
me. As the chair, I will be in the leaders from the gerombolan, you know. Yeah. So, thank you very much once again. So, ladies and gentlemen, shall we begin from the second sessions in the fourth sessions? And the speaker is Bapak Frits Edward Siregar from Indonesia Jentera School of Law Indonesia, that will outline the presentations between the people and the populace safeguarding judicial independence in the changing world. Pak Frits, 15 menit, 15 minutes, floor is yours.
Thank you, Pak. Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi dan salam sejahtera untuk kita semua. Buenos dias, good morning. And thank you for inviting me to these invitations, and thank you for Pak Pais that is already invite me. I think ICCIS is already been in Jogja, Solo, Bali, and I wonder why I joined the Jakarta conference, not in the Bali or the Solo, but maybe this is the time that I can share table with Simon and also Lutfi and also Prof. Tim. So in my previous life, before today, that I am become the Bawaslu member, and I am the responsible to about how the works of the social media and how it works and how it can change the public opinion and how it's really working in certain area in many countries. This is my intention when I draft or write this paper, and how is the work of the populists and how it happen and affect our life, particularly to the court. And let me starting my attempt how to share what is the populist and also how it works and how it affect is the court. I think from this morning experience we learn from El Salvador, we learn also from the Mexico, and we learn and we understand that it happens. So please, I will start my presentation. Please, next. So my topic is between the people and the populists. This is the idea. It takes us into the heart of global movement that is changing the way democracy works around the world. As we go through this discussion, and I hope you have time to read my paper, we find the link between the rise of populisms, the important role of the court, and how public opinion affects the balance of power. We learn from Poland, we learn from Hungary, we learn from Venezuela, and also El Salvador, and how it really works. I mean, it seems far from us, from Indonesia, but maybe we can reflect whether it's already happened here, or it just happened in Latin America. It never happened in here, but it gives time to reflect whether it's really happened to us or not. Next. So, by definition, the populism expresses the will of the people, and is often seen as a way to fix established systems that are seen as failing or exclusive. The Gracchi brothers in ancient Rome are a great example of this from history. Their agrarian reform were sort of populisms that was popular at that time. We try to fix the economic problem. They try to fix the economic problem, but they also challenge the way things were. Yet, because populism is what it is, it often goes against established rules and system. This is a dilemma. How can the opinion of the majority be balanced with rule of law? Where is there to protect everyone's rights, including the rights of minorities? In this morning, we learned from El Salvador experience where they have 6 presidents, 5 presidents has been convicted by the corrupt, and 1 guy died because of the shoot. And the people has the anger because of the existing systems. And when somebody bring the light, and it makes the populisms become rise. So the question is the problem is the new guy, or the existing political parties that cannot work they should be? Next. So, is the courts in the crosshair? With politics on the rise, judges and courts around the world are getting more attention. What is up? Court, especially constitutional court, are often the last line of defense against policy or change that might violate rights. From Turkey effort to change its court systems to the Philippines' controversial views on due process, we see a common theme: populist leaders clash with courts that try to uphold democratic principle. The pressure is just as strong today as it was in the past. So, if we learn that populism is old issue, I don't think so. I think it's the current issues. Today's issues is particularly that we are getting closer to the elections in many countries, including in Indonesia. Next. Reshaping constitutional boundaries. In Venezuela and Bolivia, we've seen how populist leaders have used constitutional change to keep their power. We learn also from El Salvador, we learn also from Mexico that they did do constitutional change. Even though this move might be what the people want, they pose serious problems of constitutionalism. They change the limit, which often make change and balances less important or even goes against them. This put the rule of law at risk. These strategies are similar to what the chapters have talked about, using what people think the majority wants to change the way democracy works. We learn also from Idul presentations how the system works in Hungary and also Poland, how they're changing the number of the people, the judges, they're changing the tenors of the judges is one of the way to make the constitutional change as the result and because it's what the people wants. Next. We understand that the court is need public support. What gives the court the power to deal with this kind of the problems? We forget that the court is established, the court is getting stronger because of the public support. There's something that I think we agree with it. That what is the answer lies in what the world thinks. In the UK, for example, public support has always played a part in upholding the court decisions, even when they seem unpopular. You cannot say enough about how important public opinion is to the role of the judges. Public support, it gives the courts the moral and social support they need to keep their independence in the face of outside pressures. Next. So it is really important for the court to get like from the people. Is the liking like what we have in our Instagram or Facebook is really has a matter to the court. How the court trying to balance to uphold the judicial independence, to uphold the rule of law, but in the other end, the court also needs to uphold the rule of law. I argue that the link between the courts and how people feel is complicated. You know, it's like relationship between two people. There is in relationship singles, but there's also complicated relationships. And using what we learned from our studies in my paper from South Africa, Colombia, and Indonesia, it is clear that the court sometimes have to make decisions that go against what the majority of people wants, especially when it comes to protecting the rights of minorities. Judiciary around the world continue to struggle with how to balance the rule of the law with the demands of populisms, or the rule of the law with demands of the publics. Next. So, how the court engaging with populisms? Is ally or adversary? Do the judges see populisms as enemy or a friends? I argue that the answer is not yes, also not no. The Arabic Spring, for example, which was a wave of populist group, did lead to democratic change in some countries, but it also make it hard to stick to the rules that has been set in place. I argue that populism is not inherently bad. It's just the expression of what the people want. But the courts need to be critical to this movement and make sure that democratic value aren't lost in that process. Next. The court need to, I assume that, strategic for resilience. We learn in my paper that I argued the example from South Africa, whether with the housing project. I argue in Colombia when they started to new term for the presidents, when the Constitutional Court also able to reject that idea. We also can look from example from Brazil to the UK to find ways that the court have kept their freedom. From improving legal framework to making decision making more open, this tactic gives judges a plan for how to handling the populist wave. By looking at the case from around the world, we can find trends and come up with plans that help the rule of law. So I argue that how other court affect and they behave against the populist attack is not have the similar standard. Some court have respond properly, and some court also willing and to accept what the populist wants. Next. We live in different conditions. Now people can produce their news. They can sharing their news. We are living that people can have the role in saying what they say and influence the public opinion. The digital age has made these situations even more complicated. Even though social media site makes information more accessible to more people, they also present problems. Populist movement, like the ones that took place during the Arab Spring, for example, can use these tools to their advantages. This digital world is double-edged sword for the judicial systems. It can be used for openness and outreach, but it can also be used to spread false news and put too much pressure on the people. Like we learned from Latin America, from the Brazil, how they use the TikTok and how use their WhatsApp. They make the WhatsApp has to changing their procedures that you only able to forward 5 times, and for the news that you already being forwarded many times that you only able to forward once. It's happened for what happens in Brazil because they see that people attack the part of using the social media as part of the movement of to influence of the public opinion. Next. So, how we can working together to protect the futures? How we working together to protect the court? As we look ahead, it's important to know that populism does not bring problems that cannot be solved. I repeat, it's important to know that populism does not bring problems that cannot be solved. Collaboration is the key to the future, whether it between court, university, civil society, or even populism group themselves. By encouraging conversation and understanding, we can make sure that the court stays strong part of democracy that protect everyone's rights and freedoms, no matter what the political winds are doing. I think one of the luxury of democracy that we have to protect freedom of speech. We have to protect people's right to say what they say, even though they say good, bad, ugly, is part of the fundamental of the democracy. But of course, the court also works with many civic society, many stakeholders, and understand this is part of the game. The court is not only just decided cases based on what we believe, what the court believes, but also but the court also has to make sure that they can hear what the people want to say, even though they say nasty things to the court. It's part of the job and part of the responsibility that the court must face. Thank you for hear my speech. Thank you for hear my presentations and looking forward for your question. Terima kasih. Wal muwaffiq warahmatullahi. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you very much, Pak Fritz. Really on time. And what you already presented, how will the court react? So it is a typical lawyer's argument. It depends. Whether it should be in the populist or the minority, it really depends. So you introduce the quasi between populisms and minorities. So to give the response, may I invite Professor Simon Bad, please.
Yes, thank you. Very interesting paper, Bang Fritz. Now you've given us a lot of food for thought in your paper. There was an emphasis on comparative perspectives, drawing on various other constitutional courts we've heard about throughout this conference. But I wanted to bring you back to Indonesia because I wanted more examples of where populism and constitutionalism might collide in the Indonesian context. That was my first question or comment. The second was you talked a lot about public support and the importance of that, which is always quite interesting, I think, from an outsider's perspective, because, you know, we're brought up in places where lawyers, you know, in Australia, for example, are brought up in places where, like it or not, the court has authority. Whether it's got public support or not, we still follow the court's decisions. Whereas in Indonesia, particularly with new institutions, relatively new institutions like the Constitutional Court, there is this public relations aspect, which I've always found quite fascinating. And I guess my question boils down to, how popular do you think the Constitutional Court is? Is it popular enough for it to sustain itself? And perhaps relatedly, compared to other institutions in Indonesia, particularly the National Parliament, how do you think its popularity compares? So is it more popular than the DPR? In which case, does that help in your assessment of the populism question?
Thank you, Prof. Simon and Pak Lutfi.
Thank you, Chairman. Fritz, I always enjoy to read your paper, honestly, frankly speaking. And I remember I suggest this theme to FAIS because I want to learn more, and I found some important issues that we need to raise, especially in the court perspective, to handle how the populist movements happens for Indonesia. And usually I just remember political scientists always talk about the social movements. And then I also learned from your paper that the populist movements and social movements are involve collective actions, but they have distinct characteristics. And while populism is often centered around a single leader and their message, social movement encompass a range of actors, ideas, and strategies to address specific social and political concerns. And based on your paper also, I found that populist movements might attempt to undermine judicial independence by various means, including the appointments, because the populist leaders might appoint judges who are loyal to them, rather than those who prioritize judicial impartiality and independence. And also legislative changes they could introduce of support laws that limit the judiciary power or alter its compositions in favor of their agenda. And the populist leader also try to reduce funding for the judiciary, can hinder its functioning and capacity to operate independently. They also try to constitutionally change, is quite some familiar for Indonesians, right? Populist movement may try to amend the constitutions, to expand their own authority over judicial appointments, removals, and decision-making process. And also, one of the most important things that retaliations that populist leaders might take retaliatory actions against judges who rule against their policies, creating a climate of fears. And they also make a public attacks. Yeah, populist leaders might use public criticisms or misinformation campaigns to erode public trust in the judiciary, weakening its authority. But the question, in the court perspective, what's next? You already mentioned that we need to try to understand the public awareness about the rule of law. To safeguard judicial independence is important for legal system to have strong constitutional protections, transparent appointment process, checks and balance, and well-informed public that values the expression of powers. But what next? For the court perspective, it needs to have kind of the extremes, or it's too extreme to call extremes, to understand these issues and kind of backsliding the populist leader, like make a contempt of court or try to impeach them. What do you think about it? Thank you so much.
Thank you, Pak Lutfi. Pak Fritz, you have two questions, but I turned it into four questions. Please respond.
Yeah. This is academic discussion, right?
Yes. Right.
Yeah. So I mean, please do not hate me by saying it. I mean, what the court doing now is getting the public support. The court since 2016 make international conference, invite all the people from all over the world. For me, at the outsider, it's showing to the world this is Indonesia Constitutional Court. We have friends from many countries, and we are established institution countries. and we are established and have knowledge among other friends. So it's part of the political support or public support. It's not only from public support from Indonesia, but also public support from all over the world, not only from the Asia but all other countries. So I assume that Indonesia Constitutional Court play its important role to get the public support locally and also internationally. Because if something happened with the court can asking for help, from local friends or from international friends. So yes, the court, I think, is very understand the role of the public support. I mean, Prof. Jimli is always say the judges must stay in the closed door and we not hear anything from outsider. But Prof. Mahfud during his time say the court must be outside, meeting with the people and say what the judges and how to get the opinion. And more we come here, at least from my point of view, the court is more often going out to outreach in the name of to share about constitutionalisms, Pancasila, Undang-Undang Dasar, but also to share the court decisions. So, in my opinion, the court did his homework to get the public support, even though the court is covering by learning about constitutionalisms and others. So, it is good or not? I think this is good, because we always feel that the court is the weakest link of all the institutions, but I'm not agree with that argument. The court is as strong as other government institutions, but the important is how the court play that part. Hendrianto books in 2018 talk about the judicial hero, like Prof. Jimli and others. Judicial hero is not always approve every legislation, but they know how to approve and they know what they not approve. Because the court is not alone. I always say that the Constitutional Court is not the only one that responsible to make this country great or not great. Other institutions also important. We also strengthening the other institution. We have to respect with their role also. So I think that's the important part, because Constitutional Court all over the world must understand how the politics works. Not only understand the rule of law, not understand the constitutions, but how to interpret the constitution today, with today's situations, with today's political context. And the Simon question is, and thank you Simon and Lutfi, you are my great supporter, you are my great mentor, and you are my great friends, and it's always push us to study, and how is whether the court collide with populist movement. I not see that whether we have populist leaders in Indonesia, but do we have populist movement? Yes, we have. And if we, in any constitutional court cases, if you look, there is always somebody that want to pursue their idea using the social media to influence the court, because the judges read the newspaper. The judges really want to see how they perceive, whether they are siding with the populist movement or not. But whether this is good or not, I think it's how the judges consider the populist movement. Because sometimes the populist movement is not bad, because also is in line what the judges wants. I think the judges has their personality, they have their own risk, they also have the future, how the system works in Indonesia, and we must accept it, because we choose justice, we use a constitutional justice with their personality. Thank you.
Thank you very much, Pak Fritz, because we lapse of times. To conclude your statement that our Constitutional Court is locally rooted and globally respected. It is a journey to this kind of achievement. Yeah? Locally rooted, globally respected. Yeah. Sorry.
Undang lagi berikutnya. Next lagi.
Sorry. It is our tagline. Sorry. Thank you very much because we lapse of time. We still have 5 minutes. Yeah. May I invite questions? All right, Pak Lutfi Cakim and then Ibu Ceklil, Ibu Intan. Ibu Cekli. My sincere apology, Ibu Cekli. Sorry. Yeah.
Thank you.
Monggo, Pak.
Okay. Thank you, Pak Jaka, and also Dr. Fritz for bringing us great discussions. I interested with your statement about we have to protect the freedom of speech, but you know there's a worrying global risk of the democratic backsliding, where the government is trying to limit freedom of speech by targeting people or someone who have different view with the government. And also in terms of the justices, there will also worrying that the government is trying to remove the justice who have different view with the government. So I will just ask your opinion about this current situation. Thank you very much.
Right, Bu Cekli.
Thank you so much, Dr. Fritz. You mentioned in your presentation that to anticipate the influence of populism on the independence of the court is to make court decision openly. So my question is, do you think that the Constitutional Court of Indonesia has already done your idea? If so, do you think that populism in Indonesia not interfere the Constitutional Court independence? Thank you.
Thank you, Bu Cekli and Mbak Intan. Bu Intan, sorry.
Okay. Thank you, Mr. Jaka. I'll make it quick. Why you take this populism movement as an object of your paper instead of why you are not study at interpretation method, just like a textual or purposive. I think that's a kind of a legal study rather than political study. I think that's all. Thank you.
Thank you, Ibu Intan. Pak Faiz?
I would like to, bit contradict between explanation from Prof. Mirza and Prof. Fritz, because it's kind of like legal studies is a bit a political studies. That's the expertise of Professor Fritz. If I compare what Prof. Mirza explained yesterday, that the court should have a strong judicial review, whatever it costs. That's the roles of the judges. While Fritz say the court should be think about the strategics, and this is also think about not only by the current bench, but also even from the first leadership of Prof. Jimli, Prof. Mahfud, because I had an opportunity to assist first Chief Justice, Prof. Mahfud, and then to Papalguna, and the last Prof. Saldi. So I would like to throw this contradictions approach, if I can say, and ask an opinion from Prof. Simon, Prof. Tim, Monica, Prof. Zoltan, which one is the best way that the court should do an approach regarding the populisms, or just close the eyes and take a decisions what matter it costs. But I'm afraid if we do that without any strategic thinking, then the parliament will attack the court, not only in Indonesia experience, but also it happened in many countries. So I would like to throw these questions to the floors as well. Thank you.
Thank you, Pak Faiz. Pak Fritz, you have 4 questions and comment, but you only have 1 minute.
Okay, so again, this is the academic discussion, right?
Right.
So for the first question, I disappointed with this current Constitutional Court justice, because when it happens to Justice Aswanto, the court should not be we reject and will not do the court, everyone resign. It's clear that the court will have the strong opinion, because the court has the strong institutions. The court will not silently when some one of them has been attacked. But the court doesn't do anything. The court just accept the new justice, not because I'm not respect to Prof. Guntur, but I respect to Prof. Guntur, but as the institutions, the court must stand up for what he believes. And did not I see from this current justice. The current justice just accept, okay, you want to attack me. You want to shoot, that's it. It doesn't let, giving reflect to the power to the president. I am an institution that established by the constitutions. That's why the court should behave. And I did not see from this current justice, but this is what, you mean what? It is not about the freedom of speech. This is the real politics between one institution and another institutions. And when the court accept one of them has been removed, so the court is just accept the fate that they easily undermined by the parliament. Of course, I'm just saying because I'm not in the court, and but but there's the risk. And also for Ibu Chekli, I'm not. The court is already have openly discussion. The transcript and decision is very important. But whether the people understand it, and whether the people can relate with, like, for example, last about the Simon paper about the tax code. Why is difference within this decision than the other the other discussion? That's the role of the court or the friends of the court to engage with the discussions, specific matter, so makes the people will understand. And the third, why I choose the populism studies? Because I'm writing my dissertation. In the first, I want to studying about constitutional interpretations. But the more that I read the constitutional interpretations, is the more that I'm not really understand it, because the judges can decide whatever they want. We want to respect constitutional interpretations. In the US, they call it the proportional interpretations, the original intent. But we choose judges as a person. So the judges can do whatever they want. There's the judicial independence, right? We give him a freedom to become a justice. So we also give them the freedom how to decide the cases, whether it's original intent, perversive, grammaticals. We cannot limit the judges. The judges has their own feeling, their own opinion. And I think the vice question is for all of us. Thank you, Pak.
Thank you, Pak Fritz, and we will respond for Pak Faiz questions for the next sessions. We hope we still have time, because time is lapsed. Thank you very much, Pak Fritz, Prof. Simon, and Pak Lutfi. Well done, well done.
Saya masih diundang kan? Kalau ngomong begitu masih diundang terus.
Right, thank you very much. We will enter into the third and the last sessions for the fourth sessions for today's. May I invite Ibu Chekli, to be the speakers, and may I also invite Prof. Tim Lindsay from Melbourne University Law Schools in Australia, as well as Ibu Winda Wijayanti as a respondent, the second respondent, please. Thank you very much, Ibu Chekli. Are you ready, Prof. Tim, Ibu Winda? But before we start, I still remember 20 years ago when I studied in Melbourne University, when I first met Pak Tim, I gave my outline of research, and he responded like this: "Oh, Jaka, you have a good outline. Oh, very good, very good. However," it is the typical Australian legal scholars, yeah. However, and then 1, 2, 3, 4, 5, 6 until 100 critics. Yeah. Thank you. Sorry, Pak Tim. So, Ibu, it is true. Ibu Chekli. So you have 15 minutes, and please present your paper regarding the threats to Indonesian Constitutional Court independence posed by religious populist movement for 15 minutes, and then I invite Prof. Tim Lindsay as well as Ibu Winda to give comments, questions, and fruitful discussions. Ibu Chekli, please.
Your opening was make me scary, actually. So please don't ask a lot of questions, Professor Tim. Good afternoon. Assalamualaikum warahmatullahi wabarakatuh. I would like to thank two honorable judges of the Constitutional Court of Republic of Indonesia for this opportunity given to me, and distinguished speakers, respondents, participants, and the committee of the ICCIS. Thank you for having me today, and it is such an honor for me to speak in this valuable event. Let me utilize my academic freedom to express my critical thoughts. We really appreciate Honorable Judge Professor Saldi's remark in yesterday opening that we are welcome to achieve the academic freedom in this forum. So I'm a witness and proud of the openness of the Constitutional Court, and I believe it is a key why the Constitutional Court continued to move in the right direction. So my topic is about threat to Indonesia Constitutional Court independence posed by religious populist movements. So next slide, please. I divided my presentation into several parts. So as you can see in the slide, and let me start with the introduction part, please. So as you may be aware, in recent years, religious populist movement, or I call RPMs, have emerged and grown in Indonesia. And many scholars maybe have indicated that RPMs have had a significant impact on politics and society in the nation and shaping public discourse and policies. However, in Indonesia, study really discuss how populist religious movement shape the independence of the judiciary, particularly the Constitutional Court. So by focusing on the Indonesia Constitutional Court, this study argues that the religious populist movement continues to advocate for the strengthening of Indonesia anti-blasphemy law in various ways and influence the court to exercise compromising independence, which can undermine democratization and the rule of law. So my study aims to examine how the RPMs in Indonesia challenge the independence of the Constitutional Court, and the second, to analyze the implication of compromising independence of the court towards democracy, the rule of law, and human rights. So next slide, please. As a theoretical framework, referring to Rosenfeld in 2000, we believe that judicial independence is a fundamental component of a democratic society and the rule of law. And moreover, Harkusa in 2021 emphasized that judicial independence refers to the freedom of the judiciary from the interference of other institutions and individuals. In Indonesia, we can see on Article 24, Paragraph 1 of the Constitution, confirm that the judicial authority is independent in administering justice. This independence indicates that judicial authority is free of the interests that influence other branches of power, as well as free of any political ideology or public pressure. So judicial independence is essential to ensure that justice is served, human rights are protected, and the legal system is legitimate and trustworthy. As mentioned in Article 20D of the Constitution, that the right to enjoy fair legal certainty and the equality treatment before the law is a human right. Furthermore, and the principle of a judge's impartiality is one of the most important principles of judicial independence. So this conceptual framework are relevant due to the authority of the Constitutional Court as the guardians of the Constitution and the protector of human rights. So next slide, please. So in this study, I follow Banakar and Travers and employs a socio-legal approach combined with the case study analysis to examine the gaps between the legal provision and a legal consideration expressed by judge in the court and what really occurred in the ground. So therefore, this study required a comprehensive qualitative analysis of the court decision and see the political context surrounding cases and comprehend with the interview to the key resource persons. Yeah, next slide, please. So before I explain the findings of this research, referring to various scholars, I will introduce the characteristic of the religious populist movement in Indonesia. So according to Lutfi in 2019 and Yilmaz and Bakhtiar in 2021, the most prominent RPM were FBI, PKS, and the National Movement to guard the fatwa of the Indonesia Ulama Council, including mass demonstration on the 4th September, the 2nd December, and their grand alumni reunion. As you can see in the slide, my research shows that these 5 characteristics are also present in the religious populist movement in Indonesia. So RPM in Indonesia instrumentalize religious discourse and use religious rhetoric and symbols to appeal to the religious sentiment of the population. So during a blasphemy trial, for example, this RPM has protested and taken vigilante action against religious minority groups. Moreover, the RPM divides society into different groups along religious and civilization, or by calling others corrupt elites or enemies and call themselves as noble ummah. So they use social media platform to political gain and public sympathy. So we can see those movements in the case of Ahok in 2016 and 2017. So next slide, please. So distinguished speakers and participants, this study found that the Constitutional Court independence challenges by religious populist groups through public protests and demonstration, political influence, social media campaign, and lobbying. So first of all, related to public protest and demonstration, I observed that religious populist movement have intimidated judges and influenced their decision by holding public protests and rallies outside the court buildings in order to prevent the court canceling the anti-blasphemy law. And during the protests, religious populist groups characterized the court as a bias or corrupt if the judgment disagree with them. This might generate a narrative that pressure the court to comply or risk public criticism. And the second is political pressure. Religious populists have been able to strengthen their political power and negotiate with mainstream political parties. Their growing influence has shaped public discourse and policies in the country. So the civilization turn in Indonesia populism has been demonstrated, for example, by the former FBI action and the discourse during the Ahok affair, in which a Christian Chinese politician was accused of blasphemy by the religious populist movement. And the third, religious populists influence public opinion. Yes, we can see that during the judicial review of the anti-blasphemy law, religious populist organizations use social media to organize supporters and influence public opinion to obtain support for the court to rule their favor. They also continue to file reports against religious minority organizations to law enforcement throughout the judicial review process. So, and the fourth is a religious populist movement supported the Indonesia anti-blasphemy law, sent the petition to the court and urged the Constitutional Court to oppose its repeal during a judicial review. One and the only judge who dissented on the anti-blasphemy law constitutionally finally abandoned her legal argument, which is the Honorable Judge Maria Farida. As a result, the Constitutional Court has delivered at least 3 judgments on judicial review of anti-blasphemy law in 2009, 2012, and 2018 that I focus in this study, and repeatedly uphold the constitutionality of the law. In one hand, the court believed that maintaining the law was necessary to prevent conflict between religions, and the law can be used to resolve it. On the other hand, the court opined that the article of the anti-blasphemy law contained ambiguous provision that could lead to discriminatory conduct. So next slide, please. So referring to Mitzer and Mutath in 2020, the study observed that religious populist organizations pushed the Constitutional Court to compromising its independence, and in blasphemy cases, a judge may give the religious populist pressure and rule accordingly. So what are the risks of the Constitutional Court independence compromising? Yes, thank you for reminding. First, the rule of law is compromised when religious and political belief influence court decision. Inconsistent and unpredictable rulings may damage public trust in the judicial system. The Constitutional Court prefers social politic interests, avoided annulling the anti-blasphemy law statute to avoid horizontal conflict. The court did not consider that vigilante groups' use of the law to legitimize violence against religious minorities. And the second, religious populism may undermine the Constitutional Court independence, hurting democracy. This study revealed that the anti-blasphemy law strengthened Indonesia's theocratic Islamic government by allowing the MUI fatwa to ban various faiths. For instance, using the MUI fatwa to justify religious restriction. Compromise the Constitutional Court independence. This study believed that religious populist movement influenced the court to exercise compromising independence, violating human rights and minority rights. And for instance, many scholars such as Forte, Biwas, Plainer, Fagan indicate that Indonesia anti-blasphemy law discriminate against minority both within and outside the court. So I think because the time is running out, so I will jump to the conclusion. Religious populist organizations in Indonesia attempt to influence the court in different ways in order to advance their political or religious agenda. This endeavor jeopardizes of the Constitutional Court bias interpretation and compliance with the Constitution. Concern arise regarding the protection of minority rights, as this movement often advocate for policies that may infringe upon those rights. And the impact of compromised judiciary on democratic governance are including the erosion of separation of power, compromise individual rights, decrease public trust in the judiciary and democratic system. And the last, my recommendation is that the Constitutional Court independence is essential for democracy, the rule of law, and human rights. Legal measure boosting judicial autonomy may prevent outside intervention. Educational and public awareness effort that promote respect for the rule of law and democracy may increase judicial independence. Last slide. Sharing best practice from other countries and seeking human rights group assistance are essential to the Constitutional Court independence. So I think that's all my presentation. Thank you so much for your kind attention.
Thank you, Ibu Cekli. Wonderful, on time, one provoking questions. Where you do not mention in your paper with regards to the religious populist movement rather than Islamic religious populist movement. Because if we know there are so many incidents, so many examples, but there is a silence for other religious populist movement, for example, for the Christians, Hindus, Buddhists, etc. So it is the first challenge. But before that, may I invite Prof. Tim Lindsay?
Yeah, I'm not sure there are many minority religion populist movements in Indonesia because Islam is a religion of 85% plus. So anyway, that was a great presentation, Ibu Cekli. However, no,
I will listen.
I didn't bring my red pen, so it's okay. Look, freedom of religion is never absolute. It's always restricted. And the classic example given is of the cannibal who says, my religion requires me to kill and eat you. So governments always restrict religion. The question isn't that it shouldn't be restricted, but to what extent. And blasphemy laws are always controversial because they privilege a particular set of abstract ideas and so forth in principle, namely religions, but in practice they actually privilege social institutions, the institutions of that religion. That's what really happens in practice. Now, that's particularly problematic when it favours one religion over others, and that's usually the majority religion. In Indonesia, it's a bit more complicated because, as well as Islam being an overwhelmingly dominant religion in the country, in addition to that, the definitions of religion in Indonesia are very limited. Those definitions, this is not widely known, but the definitions come actually from the blasphemy law itself, and it limits it to 6 religions: Islam, Catholicism, Protestantism, Hinduism, Buddhism, and a sort of reinvention of Chinese beliefs as Confucianism. And the others are not technically religions, they are faiths, and there's 2 levels of privilege. Religions have a higher privilege over the other religions, which are called faiths. And so it's not just about the majoritarian religion being privileged, it's about non-recognised religions outside the 6 being deprived of recognition. And I think that the battle to try and repeal the blasphemy law has failed in Indonesia because the Constitutional Court has repeatedly upheld it. It's pretty clear that it will keep doing that. And in fact, the Constitutional Court, I think, has never struck out a government law pertaining to religion. It always upholds government laws that relate to religion. So part of the problem, I think, also is that in its decisions, the Constitutional Court has said that religions need to be understood in terms of orthodoxy, which is determined by so-called parent organisations. And in the case of Islam, it's the Council of Indonesian Ulama, MUI. So that does 2 things. First of all, it excludes the unrecognised religions, and it gives particular institutions huge power to determine orthodoxy. So my question really, I suppose, from all that is, what actually can the Constitutional Court do? Of course, it could repeal the blasphemy law, but I doubt that's going to happen. I think that's probably impossible for a whole range of reasons. Short of that, what can it do? What can it better do to protect, but not just minority religions, but the ones who are most vulnerable, which is unorthodox religions. Religions that consider themselves part of one of the recognised religions, but which the recognised religions don't accept, because they are the ones who are particularly targeted. Would it be to remove the role of the parent religious organisations that define orthodoxy? Is it to remove the distinction between the 2 classes of recognised and unrecognised religions? Would they be ways of doing it? Because if there isn't a way of doing it, then the way it stands, I can't see any change is going to happen.
Thank you, Prof. Tim, for your insightful comments, Bu Cekli, and I think it will be a very supportive to your paper, yeah? Bu Winda, please.
Good morning, ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, Rahayu. Thank you, Mr. Chair, Dr. Heribertus Jakatriana for the time. Ibu Chekli, your paper is coherent and comprehensive regarding religious or traditional belief and the emergence of new religion that often calls as blasphemy. The literatures are up to date and comprehensive. Congratulations for the interesting paper and presentation. I really appreciate that more and more people are giving attention and carrying the other towards marginal groups such as religious belief or traditional belief and adherent the other religions besides the 6 established religion in Indonesia. My question are, the author mentioned that safeguarding the independence of the Constitutional Court is vital. So, are there any criteria that the Constitutional Court call independent from the threat? Secondly, is it possible in the future that the religious populist movement will support the state in respecting human rights, especially minority rights, not to pressure on court, maybe make a new regulation like amended the law number 1 PNPS 1965 concerning prevention of misuse and blasphemy of religion or blasphemy law. That's all. Thank you.
Thank you very much, Ibu Winda and Ibu Chekli. Please respond to all the comments.
Thank you. Thank you so much, Professor Tim, for your insightful, and this is very important for me to develop my paper. You mentioned about the right to religious freedom is not an absolute right. Yes, but then when we come to the issue related to anti-blasphemy law, there was like the fake norm that actually, you know, if we can read in Article 1, Article 2, and Article 3, the law says that we cannot interpret the other religious belief. It's mean that the religions that mentioned in the law is the 6 main religion that you mentioned. So that's why when there is a minority groups of religion that probably have different belief, it could be punished according to the law. So I think what the Constitutional Court declare in the Constitution in the decision indicated that there is the norm, that multi-interpretation that should be revised by the legislation, that should be followed by the legislative body. But because the sort of ambiguity of the decision, saying at the end of the decision saying that the law is constitutional, then probably the legislative body is think that it's not necessary to revise the law. So that's the problem why the law until today has been utilized to criminalize further the minority groups of religion. So that's actually become a big deal in my point of view. So I think to challenge the sort of the weakness of the laws can still be tried by the public, because as we learned that the law is is already criticized by the public in many times. So I think we can try to bring the case again and again in the court. So probably the Constitutional Court will change their mind. Yeah, I mean, because we learned that in a previous decision related to the KTP case, there is a very strong consideration about the non-discrimination principle that approved by the Constitutional Court. So I think there is like, you know, I mean, the Constitutional Court should give sort of consistent decision. Yeah, that's my opinion.
I don't disagree with you that that would be a good solution, but it would be extraordinary for the Constitutional Court to change its approach and actually knock out a law on religion, because it seems terrified of doing so.
I'm quite confident with this, because when the Constitutional Court decide about the KTP, probably once the Constitution announced the decision, there is such, like, you know, complaint from the certain group of religions. But then by the time doing, they just accept this decision. Yeah, so I'm quite optimistic, because actually the Indonesia people is quite open. Yeah, as long as the court is quite strong. Yeah. So for the second question, you asking about the independent criteria in terms of the to prevent the influence of population religious movement. I don't know. I don't have a specific criteria about that, but I learned from the other speaker previously that I think making a strong review is very important for the court, not in between, because if the decision is quite in between, then the political will interpret based on their own benefit. So I think that's my response.
Is enough, exactly?
Yeah.
All right. Ladies and gentlemen, because we already have lapsed the times, and as you know, today is a Friday. For the Muslims, will run the Friday prayers at 11:35, so it is really limited time. My sincere apology if I do not accommodate all your curiosity for these sessions. And from Pak's questions might be facilitated by Pak Mova in the next sessions, please. Ladies and gentlemen, first of all, thank you very much, Ibu Cekli, Prof. Tim, and also Ibu Winda. So let's end this fourth session by I quote another pantun. Pergi ke Muntilan, beli terasi, cukup sekian dan terima kasih. Thank you very much. Thank you, Pak.
Thank you, Mr. Chairman. So we have reached the end of session 4. Let's sending big applause for the chair speakers, respondents of the fourth session. Ladies and gentlemen, we have one session left. However, we'll have lunch break and Friday prayer until 1:15. And the Friday prayer venue will be at Musola Al Barkah next to Ballroom 2 of the building. So thank you very much. See you at 1:15. The 6th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of previous international symposium held in Surakarta 2017, in Yogyakarta 2018, in Bali 2019, in Bandung 2021, and in Bali 2022, the Constitutional Court of the Republic of Indonesia will hold the 6th International Symposium of the Constitutional Court in Jakarta on August 9 to 11, 2023 in a hybrid format. The Constitutional Court of the Republic of Indonesia will hold an international academic forum to discuss various strategic, legal, and constitutional issues. This year's theme, Constitutional Court and Judicial Independence, a Comparative Perspective. This international symposium will be divided into 5 sessions to discuss and elaborate provided sub-themes. First, independence of Constitutional Court in the democracy era. Second, independence of constitutional judges in the decision-making process. Third, threats to judicial independence posed by populist movements. Fourth, Constitutional Court's budget and financial independence. Fifth, Constitutional Court performance and independence of judicial staff. Please visit www.iccis.mkri.id.
Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Flo Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta jauh di rantau orang. Beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya.
The 6th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of previous international symposium held in Surakarta 2017, in Yogyakarta 2018, in Bali 2019, in Bandung 2021, and in Bali 2022, the Constitutional Court of the Republic of Indonesia will hold the 6th International Symposium of the Constitutional Court in Jakarta on August 9 to 11, 2023, in a hybrid format. The Constitutional Court of the Republic of Indonesia will hold an international academic forum to discuss various strategic, legal, and constitutional issues. This year's theme, Constitutional Court and Judicial Independence, a Comparative Perspective. This international symposium will be divided into 5 sessions to discuss and elaborate provided sub-themes. First, independence of Constitutional Court in the democracy era. Second, independence of constitutional judges in the decision-making process. Third, threats to judicial independence posed by populist movements. Fourth, Constitutional Court's budget and financial independence. Fifth, Constitutional Court performance and independence of judicial staff. Please visit www.iccis.mkri.id.
tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Bamora tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya.
The 6th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of previous international symposium held in Surakarta 2017, in Yogyakarta 2018, in Bali 2019, in Bandung 2021, and in Bali 2022, the Constitutional Court of the Republic of Indonesia will hold the 6th International Symposium of the Constitutional Court in Jakarta on August 9 to 11, 2023 in a hybrid format. The Constitutional Court of the Republic of Indonesia will hold an international academic forum to discuss various strategic, legal, and constitutional issues. This year's theme, Constitutional Court and Judicial Independence, a Comparative Perspective. This international symposium will be divided into 5 sessions to discuss and elaborate provided subthemes. First, independence of Constitutional Court in the democracy era. Second, independence of constitutional judges in the decision-making process. Third, threats to judicial independence posed by populist movements. Fourth, Constitutional Court's budget and financial independence. Fifth, Constitutional Court performance and independence of judicial staff. Please visit www.iccis.mkri.id.
Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Flo Bamora, tanah airku yang tercinta, beta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya.
The 6th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of previous international symposium held in Surakarta 2017, in Yogyakarta 2018, in Bali 2019, in Bandung 2021, and in Bali 2022, the Constitutional Court of the Republic of Indonesia will hold the 6th International Symposium of the Constitutional Court in Jakarta on August 9 to 11, 2023, in a hybrid format. The Constitutional Court of the Republic of Indonesia will hold an international academic forum to discuss various strategic, legal, and constitutional issues. This year's theme, Constitutional Court and Judicial Independence, a Comparative Perspective. This international symposium will be divided into 5 sessions to discuss and elaborate provided subthemes. First, independence of Constitutional Court in the democracy era. Second, independence of constitutional judges in the decision-making process. Third, threats to judicial independence posed by populist movements. Fourth, Constitutional Court's budget and financial independence. Fifth, Constitutional Court performance and independence of judicial staff. Please visit www.iccis.mkri.id.
Bamora, tanah airku yang tercinta, tempat betu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo. Rasa kirang dan badendang pulange. Meski beta lama jauh di rantau orang, beta ingat bama janji pulange. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo. Rasa kirang dan badendang pulange. Flo Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulange. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo. Rasa kirang dan badendang pulange. Meski beta lama jauh di rantau orang, beta ingat bama janji pulange. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo. Rasa kirang dan badendang pulange.
Untuk bangsa ini
The 6th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of previous international symposium held in Surakarta 2017, in Yogyakarta 2018, in Bali 2019, in Bandung 2021, and in Bali 2022, the Constitutional Court of the Republic of Indonesia will hold the 6th International Symposium of the Constitutional Court in Jakarta on August 9 to 11, 2023 in a hybrid format. The Constitutional Court of the Republic of Indonesia will hold an international academic forum to discuss various strategic, legal, and constitutional issues. This year's theme, Constitutional Court and Judicial Independence, a Comparative Perspective. This international symposium will be divided into 5 sessions to discuss and elaborate provided subthemes. First, independence of Constitutional Court in the democracy era. Second, independence of constitutional judges in the decision-making process. Third, threats to judicial independence posed by populist movements. Fourth, Constitutional Court's budget and financial independence. Fifth, Constitutional Court performance and independence of judicial staff. Please visit www.iccis.mkri.id.
Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Flo Bamora, tanah airku yang tercinta, beta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya.
The 6th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of previous international symposium held in Surakarta 2017, in Yogyakarta 2018, in Bali 2019, in Bandung 2021, and in Bali 2022, the Constitutional Court of the Republic of Indonesia will hold the 6th International Symposium of the Constitutional Court in Jakarta on August 9 to 11, 2023, in a hybrid format. The Constitutional Court of the Republic of Indonesia will hold an international academic forum to discuss various strategic, legal, and constitutional issues. This year's theme, Constitutional Court and Judicial Independence, a Comparative Perspective. This international symposium will be divided into 5 sessions to discuss and elaborate provided subthemes. First, independence of Constitutional Court in the democracy era. Second, independence of constitutional judges in the decision-making process. Third, threats to judicial independence posed by populist movements. Fourth, Constitutional Court's budget and financial independence. Fifth, Constitutional Court performance and independence of judicial staff. Please visit www.iccis.mkri.id.
Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Flo Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulange. Menjaga dan mentaati konstitusi untuk bangsa Indonesia.
The 6th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of previous international symposium held in Surakarta 2017, in Yogyakarta 2018, in Bali 2019, in Bandung 2021, and in Bali 2022, the Constitutional Court of the Republic of Indonesia will hold the 6th International Symposium of the Constitutional Court in Jakarta on August 9 to 11, 2023, in a hybrid format. The Constitutional Court of the Republic of Indonesia will hold an international academic forum to discuss various strategic, legal, and constitutional issues. This year's theme, Constitutional Court and Judicial Independence, a Comparative Perspective. This international symposium will be divided into 5 sessions to discuss and elaborate provided sub-themes. First, independence of Constitutional Court in the democracy era. Second, independence of constitutional judges in the decision-making process. Third, threats to judicial independence posed by populist movements. Fourth, Constitutional Court's budget and financial independence. Fifth, Constitutional Court performance and independence of judicial staff. Please visit www.iccis.mkri.id.
Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulange. Meski beta lama jauh di rantau orang, beta ingat bama janji pulange. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa kirang dan badendang pulange. Flo Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulange. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa kirang dan badendang pulange. Meski beta lama jauh di rantau orang, beta ingat bama janji pulange. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa kirang dan badendang pulange.
The 6th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of previous international symposium held in Surakarta 2017, in Yogyakarta 2018, in Bali 2019, in Bandung 2021, and in Bali 2022. The Constitutional Court of the Republic of Indonesia will hold the 6th International Symposium of the Constitutional Court in Jakarta on August 9 to 11, 2023 in a hybrid format. The Constitutional Court of the Republic of Indonesia will hold an international academic forum to discuss various strategic, legal, and constitutional issues. This year's theme, Constitutional Court and Judicial Independence, a Comparative Perspective. This international symposium will be divided into 5 sessions to discuss and elaborate provided sub-themes. First, independence of Constitutional Court in the democracy era. Second, independence of constitutional judges in the decision-making process. Third, threats to judicial independence posed by populist movements. Fourth, Constitutional Court's budget and financial independence. Fifth, Constitutional Court performance and independence of judicial staff. Please visit www.iccis.mkri.id.
Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa girang dan badendang pulange. Meski beta lama jauh di rantau orang, beta ingat bama janji pulange. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa girang dan badendang pulange.
The 6th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of previous international symposium held in Surakarta 2017, in Yogyakarta 2018, in Bali 2019, in Bandung 2021, and in Bali 2022, the Constitutional Court of the Republic of Indonesia will hold the 6th International Symposium of the Constitutional Court in Jakarta on August 9 to 11, 2023, in a hybrid format. The Constitutional Court of the Republic of Indonesia will hold an international academic forum to discuss various strategic, legal, and constitutional issues. This year's theme, Constitutional Court and Judicial Independence, a Comparative Perspective. This international symposium will be divided into 5 sessions to discuss and elaborate provided subthemes. First, independence of Constitutional Court in the democracy era. Second, independence of constitutional judges in the decision-making process. Third, threats to judicial independence posed by populist movements. Fourth, Constitutional Court's budget and financial independence. Fifth, Constitutional Court performance and independence of judicial staff. Please visit www.iccis.mkri.id.
tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Bamora tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Untuk
The 6th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of previous international symposium held in Surakarta 2017, in Yogyakarta 2018, in Bali 2019, in Bandung 2021, and in Bali 2022, the Constitutional Court of the Republic of Indonesia will hold the 6th International Symposium of the Constitutional Court in Jakarta on August 9 to 11, 2023 in a hybrid format. The Constitutional Court of the Republic of Indonesia will hold an international academic forum to discuss various strategic, legal, and constitutional issues. This year's theme, Constitutional Court and Judicial Independence, a Comparative Perspective. This international symposium visit.iccis.mkri.id.
Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangin. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangin. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa girang dan badendang pulangin. Flo Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangin. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulange. Meski beta lama jauh di rantau orang, beta ingat bama janji pulange. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulange.
The 6th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of previous international symposium held in Surakarta 2017, in Yogyakarta 2018, in Bali 2019, in Bandung 2021, and in Bali 2022, the Constitutional Court of the Republic of Indonesia will hold the 6th International Symposium of the Constitutional Court in Jakarta on August 9 to 11, 2023, in a hybrid format. The Constitutional Court of the Republic of Indonesia will hold an international academic forum to discuss various strategic, legal, and constitutional issues. This year's theme, Constitutional Court and Judicial Independence, a Comparative Perspective. This international symposium will be divided into 5 sessions to discuss and elaborate provided sub-themes. First, independence of Constitutional Court in the democracy era. Second, independence of constitutional judges in the decision-making process. Third, threats to judicial independence posed by populist movements. Fourth, Constitutional Court's budget and financial independence. Fifth, Constitutional Court performance and independence of judicial staff. Please visit www.iccis.mkri.id.
Bamora, tanah airku yang tercinta, beta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Bamora tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya.
The 6th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of previous international symposium held in Surakarta 2017, in Yogyakarta 2018, in Bali 2019, in Bandung 2021, and in Bali 2022, the Constitutional Court of the Republic of Indonesia will hold the 6th International Symposium of the Constitutional Court in Jakarta on August 9 to 11, 2023, in a hybrid format. The Constitutional Court of the Republic of Indonesia will hold an international academic forum to discuss various strategic, legal, and constitutional issues. This year's theme, Constitutional Court and Judicial Independence, a Comparative Perspective. This international symposium will be divided into 5 sessions to discuss and elaborate provided subthemes. First, independence of Constitutional Court in the democracy era. Second, independence of constitutional judges in the decision-making process. Third, threats to judicial independence posed by populist movements. Fourth, Constitutional Court's budget and financial independence. Fifth, Constitutional Court performance and independence of judicial staff. Please visit www.iccis.mkri.id.
Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Flo Bamora, tanah airku yang tercinta, beta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa girang dan badendang pulangnya.
The 6th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of previous international symposium held in Surakarta 2017, in Yogyakarta 2018, in Bali 2019, in Bandung 2021, and in Bali 2022, the Constitutional Court of the Republic of Indonesia will hold the 6th International Symposium of the Constitutional Court in Jakarta on August 9 to 11, 2023, in a hybrid format. The Constitutional Court of the Republic of Indonesia will hold an international academic forum to discuss various strategic, legal, and constitutional issues. This year's theme, Constitutional Court and Judicial Independence, a Comparative Perspective. This international symposium will be divided into 5 sessions to discuss and elaborate provided sub-themes. First, independence of Constitutional Court in the democracy era. Second, independence of constitutional judges in the decision-making process. Third, threats to judicial independence posed by populist movements. Fourth, Constitutional Court's budget and financial independence. Fifth, Constitutional Court performance and independence of judicial staff. Please visit www.iccis.mkri.id.
Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Flo Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang Anak timur main sasando dan menyanyi boleh lebo, rasa girang dan badendang pulange. Menjaga dan mentaati konstitusi untuk bangsa Indonesia.
The 6th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of previous international symposium held in Surakarta 2017, in Yogyakarta 2018, in Bali 2019, in Bandung 2021, and in Bali 2022, the Constitutional Court of the Republic of Indonesia will hold the 6th International Symposium of the Constitutional Court in Jakarta on August 9 to 11, 2023, in a hybrid format. The Constitutional Court of the Republic of Indonesia will hold an international academic forum to discuss various strategic, legal, and constitutional issues. This year's theme, Constitutional Court and Judicial Independence, a Comparative Perspective. This international symposium will be divided into 5 sessions to discuss and elaborate provided subthemes. First, independence of Constitutional Court in the democracy era. Second, independence of constitutional judges in the decision-making process. Third, threats to judicial independence posed by populist movements. Fourth, Constitutional Court's budget and financial independence. Fifth, Constitutional Court performance and independence of judicial staff. Please visit www.iccis.mkri.id.
Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa girang dan badendang pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa kirang dan badendang pulange. Flobamora tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa kirang dan badendang pulange. Meski beta lama jauh di rantau orang, beta ingat mama janji pulange. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa kirang dan badendang pulange.
The 6th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of previous international symposium held in Surakarta 2017, in Yogyakarta 2018, in Bali 2019, in Bandung 2021, and in Bali 2022, the Constitutional Court of the Republic of Indonesia will hold the 6th International Symposium of the Constitutional Court in Jakarta on August 9 to 11, 2023, in a hybrid format. The Constitutional Court of the Republic of Indonesia will hold an international academic forum to discuss various strategic, legal, and constitutional issues. This year's theme, Constitutional Court and Judicial Independence, a Comparative Perspective. This international symposium will be divided into 5 sessions to discuss and elaborate provided sub-themes. First, independence of Constitutional Court in the democracy era. Second, independence of constitutional judges in the decision-making process. Third, threats to judicial independence posed by populist movements. Fourth, Constitutional Court's budget and financial independence. Fifth, Constitutional Court performance and independence of judicial staff. Please visit www.iccis.mkri.id.
Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa girang dan badendang pulangnya. Flo Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulange. Meski beta lama jauh di rantau orang, beta ingat bama janji pulange. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulange.
Good afternoon, ladies and gentlemen. Welcome back to the last sessions of the 6th Indonesian Constitutional Court International Symposium 2023. And now we are about to start the last sessions with sub-theme, Constitutional Court Performance and Independence of Judicial Staff. And to chair these sessions, I'd like to invite Mr. M. Mofa Al-Afghani, PhD, from Faculty of Law, University of Ibnu Khaldun, Indonesia. And the speakers are Mr. Osaid Auda, PhD from Hebron University, Palestine, and Mr. Justin Epperson from William and Mary Law School, the United States of America, that will join virtually. So without further ado, Mr. Chairman, the floor is yours.
Thank you very much. Very good afternoon, everyone. This is the most difficult session of the day due to our digestive system. However, we have two exciting presentations that is guaranteed to be an eye-opener, both figuratively and also literally. So I think without further ado, I would like to invite our speaker, Dr. Osaid Awauda, and our respondents, Professor Mirza, Mr. Muhammad Reza, and Mbak Intan to come forward. Thank you. Osaid, the floor is yours.
Thank you so much, Professor. Assalamu alaikum wa rahmatullahi wa barakatuh, and good afternoon to you all. May I ask the organizer just to play the PowerPoint slides? Play the slides, please. Okay, as you can see in the background, this is the Dome of the Rock. The Dome of the Rock is a building situated inside Al-Aqsa Mosque. And Al-Aqsa Mosque was the first Qibla, or the first direction of prayer to the Muslims, as you all know. And it was the destination of the night journey given to the Prophet sallallahu alaihi wasallam, peace and blessings be upon him. I always start my presentation with this specific slide, reminding myself that if we went to liberate Jerusalem from the Israeli occupation, we first should liberate ourselves from the corrupt authoritarian government that is residing in the West Bank. So that is the first step to do in order to move to the next high goal of liberating Palestine, the country around which the hearts of all Muslims around the world do orbit. So, proceeding to the core of the presentation, the title of my paper is Assessment of de jure Judicial Independence of Constitutional Courts According to International Guidelines. And I can expect every one of you to think, if there is a de jure judicial independence, what should be the other type of judicial independence? It is simply de facto judicial independence. And the reason why I had to distinguish between de jure judicial independence and de facto judicial independence is the fact that having a de jure judicially independent court doesn't mean and doesn't lead to a de facto judicially independent court. Let me explain. When you say de jure independence, you are describing the independence of the court according to its law. Does the law allow for personal independence, institutional independence, procedural independence, and so on? So it is the independence of the court on paper, without looking to the reality, without looking to the facts on the ground, whether the court is in fact independent or not. But when you talk about de facto judicial independence, you are not assessing the independence of the court according to the law that governs it, but you are assessing the independence of the court according to the rulings and the judgments that it makes. What would amount to being a de facto judicially independent court? Two things. If judges have complete autonomy over the decisions, and second, if the court has proper influence. What we mean by autonomy is the fact that judges do interpret the law and apply it as they consider it to be true, without any calculations or without any considerations of undue pressure coming either from the executive branch or coming from the legislative branch. And when you talk about influence, we are talking about the effectiveness of this court. Are the judgments made by this court being obeyed and applied, executed properly and correctly by the executive branch or not? So when you say assessing the de jure judicial independence of the court, you are saying whether the law of the court allows it to be independent or not. But when you say de facto independence of the court, you are asking yourself whether the court, in fact, on the ground, does provide proper, qualified, justified judgments, well-argued, well-reasoned judgments, or not, and whether the judgments of the court are being properly obeyed and executed by the executive branch or not. So when we talk about independence, let me summarize. We talk about judges being independent from undue pressure, whether executed explicitly or implicitly by the executive branch or the legislative branch. Why they want to be independent? In order to achieve the main goal of any court, that is to uphold the law. What is the top? What is the utmost, the superb rules in any constitution, in any legal system? The rules of the Constitution. So when you talk about a constitutional court, that court should be independent in order to uphold the Constitution. If it upholds the Constitution through well-reasoned, well-justified judgments, the court is doing its job and being effective. Now, can you please go back to the previous slide? If the court is providing poor-reasoned, ill-justified judgments, then even if the law of the court makes it appear as independent, in fact, de facto, the court is not independent. So the court should depend only on one thing, As they say in the American Constitution, God and the trust of the people. But if we want to explain it in our context, they should depend only on the faculty of reason or the qualification that judges have. What makes you believe that a certain court made a correct decision? If you agree with its reasoning or justification. So the court, in order to gain trust, to gain credibility, and to be convincing in its judgments, the court must provide well-reasoned, well-justified judgments. And I believe this is crucial, because you can easily get a de jure independent court. But again, that would not necessarily mean that the court will be de facto dependent. And let me make a quick note here. I believe the democratic system inherently has the characteristic of putting the judiciary always in danger. Democracy, in a sense, is the rule of democracy, the rule of the people. And the majority of the people throughout history are easily manipulated and can be easily misguided. So the one who controls the money, the one who controls the media, can make the majority go towards any kind of decision, any kind of approach, or any kind of direction that he wants. I mean, the man who controls the money and who controls the media. And you cannot always rely on the majority to make sure that they will make wise and well-reasoned decisions. So always the legislators, the political parties, either the dominant party or the majority party in a non-dominant democratic party system, they will always try their best to deceive and misguide the majority, to get their support in order for those parties to defeat their competitors and other minor parties. Which means that they have no ethics in mind, and they have no higher values, metaphysical values that they believe in. What they believe in is only one thing, that is the lust, the unsatiated lust for power and for money. And they will do anything that is necessary to defeat anyone who could take those two lustful things from them, power and money. And by the way, this reminds me with a verse in the Holy Quran, in which Satan said to Adam when he was in the Garden of Eden, هل أدلك على شجرة الخلد وملك لا يبلى? O Adam, don't you want me to lead you to the tree of eternity and to a kingdom that never vanishes? So again, Satan played on the two unsatiable lusts of the human being, lust for power and the lust for money. Democratic systems allow the political parties to always seek those two lusts. And for this reason, the courts will always be in trouble. Because the only thing that can prevent a political party from being a vicious monster and unethically or illegally destroy all of the other political parties that are competing with it is the Constitution. And who interprets the Constitution? The Constitution doesn't interpret itself. The one who interprets the Constitution are the constitutional courts. Again, this is the reason why I believe that courts and the judiciary will always be in trouble in democratic systems. And I remember when I participated in the World Congress of Constitutional Law last December in South Africa, I had a similar discussion with two of the top constitutional jurists in Spain and in Argentina. And they all said something that was shocking to me at first. They said that we believe that democracy is the least of all evils. It is the least dangerous option. But we at the same time recognize and admit that it is indeed dangerous. Because you are relying on the majority. And the majority throughout history can easily be misguided and can easily be deceived. So again, next slide please. So to summarize what I've just said, this is the difference between de jure and de facto independence. De jure, the law of the court; de facto, its performance. If there is lack of de jure independence, then that would certainly lead to de facto independence, de facto lack of independence. But the opposite is not correct. So if you have a de jure independent court, this doesn't necessarily mean that you would have a de facto independent court. I'll give an example, the tale of two judges. Muhammad is the name of our former Chief Justice, Muhammad Al-Haj Qasim. He was single-handedly appointed by the president after serving for more than 11 years as a constitutional law professor in Morocco. And the reason why he was chosen, because before his appointment, he published a news article saying that whatever the president does, it can be justified by the Palestinian Basic Law. We do not have a constitution. The president, for sure, felt very happy reading this journal article by Muhammad al-Haj Qasim. And after 2 months, he appointed him to be the Chief Justice. He started telling people that we are an independent court and we try to build a constitutional heritage of Palestine, which is complete crap, actually. Now for the other judge, that is Judge Khalid, I was taught by this professor in Birzeit University. I should say that he is not a specialist in constitutional law. In fact, his background is commercial law. But he was appointed because he is a university professor, and the law of the court allows for appointing university professors to the court. I think the security apparatus expected him to be in alignment with the regime, but he did the opposite. When one of my colleagues, a lawyer, Dr. Bassam, and I submitted a constitutional case against the Palestinian president's decision to postpone the elections, he was one of the judges who ruled on this case. To give you a quick summary with the 4 minutes that I have. In 2021, the Palestinian president said that we should have presidential and parliamentary elections, not out of his own will, but because of the pressure coming from the Europeans and the Americans, along with the United Nations and the European Union. And when he did call for the elections, he realized that he will certainly lose for Hamas. Hamas is the Islamic resistance movement that won the elections in 2007. But they were dismissed because they, according to what the United States said, they held values that are against international values. They did not recognize Israel's right to exist. So again, democracy, but it should be according to Western standards. Democracy according to Islamic standards is democracy no more. So we submitted this application to the Constitutional Court saying that the president's decision to postpone the elections violate the basic law of Palestine. Violates the basic law in Palestine because the administrative courts have no right to oversee acts of sovereignty. And administrative courts in Palestine said that the president's decision to postpone the elections is an act of sovereignty. And acts of sovereignty are injusticiable. They fall outside of the scope of administrative courts in Palestine. So we went to the Constitutional Court saying, excluding acts of sovereignty from constitutional review is in fact a violation of Palestinians' right to to seek redress from justice or to access courts. And we ask the court to decide that this exception this exclusion is unconstitutional. Unfortunately, 8 of the 9 judges decided against our case, saying that the separation of powers principle, listen to this nonsense, the separation of powers principle necessitates excluding certain actions from the executive power from the oversight of the judicial power. So excluding acts of sovereignty from judicial or administrative review is in fact a correct application of the principle of separation of power. Very innovative in the negative sense of the word, that's for sure. But Judge Khalid dissented, saying that depriving Palestinians from the right to challenge acts of sovereignty is in fact a violation of their constitutional right to seek redress from the judiciary or to access justice. I understand that this might be heartbreaking or disheartening to many legal jurists working to reform in their countries. But as I said the other day to Professor Simon, I believe that seeking good is enough as an honor for someone, even if you do not guarantee that you will achieve it. If you can please move to the next slide. Go to the last slide, please. I've already explained this very quickly. So again, what does it mean? Sorry, I'll go for the last one. I should cover it. Yeah, go to the last slide, please. I'll go to the last question, which is the inner watch. Now, we might disagree about this, but I believe that the only guarantee for judicial independence is not solely de jure independence or de facto independence. I believe it is to build an inner watch, or we call it in Arabic ad-damir, in each judge's heart. If you have faint-hearted or you have corrupt-hearted judges, whatever kind of laws you enact, certainly the judiciary won't be independent. But if you can guarantee proper education for judges in order to make them lion-hearted or to make them to make them have strong will to oppose the regime and say the word of truth, then I believe in that way you can certainly achieve de facto independence, even if the law of the court doesn't allow it. I have less than 20 seconds left, so I will stop here. Thank you so much for listening.
Thank you very much, Osaid. I think in Osaid's paper he also explained about different kinds of international guidelines for assessing judicial independence, which is very interesting because someone asked about, is there a grand theory of judicial independence? So maybe this could be a start from that. We'll now ask Professor Mirza to provide short comments. I think we have 3 respondents now, so each of you have around 3 minutes.
Okay, thank you so much, Chairman. Osaid, it was a very insightful presentation, and as Mr. Chairman said, we are in the very dangerous time. But hearing your presentation, really woken my insight. Thank you so much for that. I'm not sleepy anymore because this is a very interesting topic to discuss. So first of all, I would like to congratulate. I read the paper, the pool paper, and I think it is a very deep theoretical analysis. You talk about the independence of judiciary from both sides, the de facto and also de jure, and you also highlight about the separation of powers as well, and the relation between separation of power and independence of judiciary, which I couldn't agree more, because the violation of independence mostly happen when the system of separation of power is crumbled. Yeah. And I also agree that as a human, we simply cannot 100% independence, and democracy itself needs to be seen in the very realistic lens, right? So democracy is not perfect, like Mahathir Muhammad said that democracy is not the perfect one, but it is the most feasible one. I still uphold with that perspective. And I also highlight that Osaid also, Dr. Osaid also mentioned about ICCPR in his paper, and I also agree with that because the effect of the independence of judiciary also can affect the political and civil and political rights of citizens to get the impartial court system. And I also have I think it's quite friendly comments. Yeah, you mentioned assertively that de facto is the most important one. Yeah, kan? The inner watch is more important than the facto one, the institution one. I remember my discussion with Professor Tim. Professor Tim also mentioned that in Australia, the norm is not perfect as well, right? It's still general, but somehow it works in Australia because of the legal culture. The responsible governments may be adopted by the Westminster parliamentary system that absent Indonesia, unfortunately. Yeah, we are French-Dutch ex-colonial, so we don't get that kind of legal culture. So yeah, I think that's quite reasonable to say that argument. But I think, in my personal opinion, I think de facto and de jure are equally important. So I agree that de facto is also important, but I think both of them can be can be run consecutively. So we need to fix the norms, the institution, but on the other hand, we also need to, but we cannot rely on individual, right? We cannot rely on one individual that have a very noble perspective on integrity or independency, something like that. I think we cannot also rely on de facto. Yeah, we also need to rely with the system. I'm a strong believer of the reform of the system rather than the reform of the individuals. Even though I agree that de facto, the integrity is also important. And maybe the last comment, I would like to link it to Indonesian experience nowadays. So the independence of judiciary, or the freedom from, is not only freedom from the executive, but also freedom from the power relations within the court itself. Yeah, kan? Indonesia has a challenge now, like in the Supreme Court. Yeah, Supreme Court has a very hierarchical, and when the Chief Justice issued some circular letter, It is very controversial in Indonesia. When he issued the circular letter, the judges also need to obey that. What do you think about that intervention from the power relation within the court itself? Thank you.
Thank you. Okay. Now moving on to our second respondent, Mr. Muhammad Reza.
Okay, thank you for this golden opportunity. I really appreciate your presentation. It's very fascinating paper. So in my opinion, I completely agree with you. There is a gap between court independency written in the regulatory, in the code of ethics and implementation. So even though we know that there is several cases that even the justices violate the independence by themselves, and they get sanctioned. And that is why, in my opinion, we not always see the factor, but also try to improve the jury, the regulation, the code of ethics. So there is nowadays problems or dynamic in Indonesia Constitutional Court about how we get the ideal model to oversight the code of conduct to the justices. So in fact, there is disparity how we try to oversight the justices in Indonesia. For example, Judicial Commission in Indonesia can only oversight the Supreme Court justice and the judge below the Supreme Court. But the Constitutional Court, they doesn't have external body to oversight their code of conduct. And I really want to know your opinion. Is it really have effect? There is special body to uphold the code of conduct by the judges. And my second question is about maybe you can elaborate more the condition in Palestine. Is there any implication when there is conflict between the country, Israel and Palestine, and maybe even there is conflict between the citizen in Israel and the Palestine, how it can affect, is it interfere the independence of Supreme Court and the judges in Palestine? Thank you.
Thank you. Now our third respondent, Mbak Intan.
Thank you, Mr. Mufa. I'm glad to see you, Mr. Osaid. Your paper has an issue about judicial independence from the textual context. I mean, influence with implementation process, and then more specifically, the textual context is from United Nations guidance. And then you also elaborate what is the obstacle of the court faces around the world, that about how to build a strong and independent and also impartiality about the judges, court, and also every cases in the world. And I'm interested with the topic about the judge appointment and also removal. And you also greatly describe about how to build independent court against the political pressure. And also you mentioned cases about the sovereignty from your country, and I appreciate that. But in Indonesia, we faced the similar cases. Our judge removed by legislative without a proper trial, I guess. So I write a paper about the impeachment of a judge, and I searched several cases. So the point is, I have no questions of your paper, but I have a brief short response for you, and then I will talk about what exactly reasoning why I interest with removal judge. I mean, In my country, facing those experience is mean a lot to impartiality of our court, and the problem is the principle of independency of using interpretation method is not my problem actually. The problem is we didn't have any procedural law that ruling for the impeachment trial for judge. We only have a impeachment trial for president and vice president. And in another country, maybe we facing same situation kind of several cases in the United States.
Your time is up.
Oh, okay. I mean, the removal process that you didn't mention in your paper, maybe you can elaborate more, is about what is the reasoning behind the authority to ruling impeachment for judicial branch. I found in several articles it said about popular constitutionalism and legal constitutionalism. It's
Okay,
debate.
I think I've taken note of the question, then I'll ask.
Okay. Maybe we can talk later.
Yeah, thank you. And we are going to take a question from Zoom. I saw that there are some questions there. If not, then we can go directly to the audience in the room. I guess not. Again, we can go directly to Prof. Tim. Go ahead, Prof.
Thanks, Jose. It's a topic for us.
The mic.
Thank you, Jose. It's a familiar topic for you and I don't think anyone would disagree that it's vitally important that the judges in a court of constitutional review have an appropriate sense of conscience and of commitment to the principles that should guide the court. And I don't think anyone would disagree with you about that, but I think it's a lot more difficult to suggest how that is to be achieved. Is it through selection? Is it through education? Is it some other way? That's not so much a criticism as a comment that this throughout the discussions at this event, we've frequently come back to the question of culture, and I'm responsible for having done that myself, although I often ban my students from using the word culture because it's usually a sort of vague term used to mean anything they can't define. And forcing people to define what they mean by culture gets you another step into the analysis. So I've broken my own rule when I used culture in my own presentation. But I suppose what I'm trying to say is what specifically can be done to create that sort of judicial conscience that you're saying will make a difference?
Thank you, Professor Tim. Thank you for all the respondents. I'll start responding in the same order of the questions. So, Professor Mirza, you asked about independence within the judiciary and also the importance or the equal importance of the de facto and de jure independence. For sure, I agree with that. And as I said, de jure independence is a prerequisite and a necessary condition for the independence of courts. But again, it's not a sole cause for the independence of the court, and it's also not sufficient for the independence of courts. So you must always be aware that having a de jure independent court doesn't necessarily mean that you will have a de facto independent court. You cannot guarantee that the judges will make autonomous and effective influential judgments just because the law of the court protects it, in theory, from undue pressure. For the question asked by the brother here, the respondent, he asked about having a code of conduct and the effect of the occupation. Now, with regards to the effect of the occupation, I think those who are aware of the historical background of the Palestinian system, Hamas, the Islamic Party, participated in the election in 2007 and they won 2/3 of the parliament. Once they won 2/3 of the parliament, the Israelis arrested every single parliamentarian from Hamas government. So the parliament could not have enough quota to hold valid sessions. And the parliament, in fact, became paralyzed. And also the international community decided to cut any kind of financial or funds support for the Palestinian government, claiming that it does not recognize Israel's right to exist. For that reason, in the Western side, it lacks legitimacy. So again, I believe the reason why we still have an authoritarian regime in Palestine is because of the Israeli support for this government to continue having that stronghold on the ruling in Palestine. So for sure, brother, it's a principal effect that the Israeli occupation is exercising over the Palestinian government in the West Bank, as opposed to Gaza Strip, for sure. Now, with regards to your question about the removal of judges, now for sure, judges are human beings, and human beings are not infallible. They are susceptible to deception, susceptible to seduction, and so on. And for this reason, we do have removal procedures. But again, removal procedures must be placed in a way that guarantees that the judges are fairly and justly being removed for reasons that are acceptable or reasons that are appropriate, such as breaking the law of conduct, or, for example, which is the most important reason, I believe, providing poor reasoned or ill-justified judgments. Now, moving to the question asked by Professor Tim, about how can you guarantee that a certain judge will be a lion-hearted judge, as I said, someone with integrity, commitment, and the ability to issue proper judgments. We might disagree about the answer that I'm going to give, but I believe religion is the most effective way to guarantee ethical commitment. And in religion, I specifically point to the belief in the hereafter, or the day of judgment, or the fact that you will be held accountable for your actions. Take this example. If we have two judges in a constitutional court, the one is an atheist, and the second one is a Muslim who believes that there is a day of judgment and he will be held accountable. Take the atheist judge, for example. The atheist judge might easily be, in some cases, might easily do the following calculation, saying, look, I will only live once. And this is my only chance to enjoy this life and have the utmost gratification of lusts and in vain desires. So I should not miss any chance to give me some money to do a certain judgments or to do a certain action just in order to receive worldly benefit. While for the Muslim judge who believes in the hereafter, you cannot seduce him, and you cannot convince him to take a certain amount of money to enjoy a high social status or to enjoy something in this worldly life, because he believes that this worldly life is temporary while the hereafter is permanent. So he would never ever prioritize what is temporary over what is permanent. I understand that given the Western influence on many educational systems in the current world, the thing that I've just said might sound as unconvincing or very much away from reason or logic. But I disagree with that. And I believe that we in the Muslim countries, especially Indonesia, that we must make sure that the religious values should be incorporated into our education system. And that way you guarantee that you have, as I said, people with lion-hearted wills who cannot easily be conceived or not easily be seduced. Thank you.
Thank you. It's a very interesting answer, although leads to another question whether, for example, values could only come from religion or many other debates. But that's, I think the point is on the internal value guidance. So the human, the culture, and also the systems always remains the question. Do you have time for another questions or? Any other questions for Dr. Said? Otherwise, then we can close the session and move on to the next session. Okay, let's give big hands to our presenters and respondents. Thank you very much. For the second presentation, we have Mr. Justin B. Epperson, who is going to present a paper regarding budgetary independence. And we have two respondents, Osaid and also Dr. Irfan Rahman. So Osaid, you can stay here. Right. Okay, Justin would be online. Okay, thank you. Thank you very much. As I said earlier, we are going to have a presentation from Mr. Justin B. Epperson regarding budgetary independence in the United States. Mr. Epperson, can you hear us?
Yes, I can hear you all. Can you hear me? And
Yes,
can you see my
very
screen?
clear. That's loud and clear. Thank you. Okay, now, Mr. Epperson, please go ahead with your presentation. The floor is yours.
Sure, thank you. First, I'd like to thank the Symposium Committee for inviting me to share my presentation and paper about budgeting independence of the American judiciary, and for allowing me to listen to all your lovely presentations and participate in this conversation. So first, we've remarked several times about the weaknesses of the judiciary relative to the other branches. It's often called the weakest branch. It's armed only with its judgments, and the power of its rulings comes from public trust and confidence, and the perception of its constitutional role. Meanwhile, the legislature has the power of the purse, and the courts rely on the legislature and the executive in order to fund them and support their mission. So this is a natural place of tension where there's strained relations between the branches, and a place where the legislature, the executive, can seek to put pressure on judicial decision making. So in context, number one, there's been in the United States politically motivated attacks on judicial independence, threats, and efforts to intimidate the justices and the judges by attacking their budgets to defund the courts. And separately, mostly this happens after recessions. There are frequent cycles of discussions about financial security of the courts, when we're talking about austerity measures applying to the judiciary to tighten their budgets. And sometimes that can leave the courts in a position where they're just enfeebled and unable to carry out their constitutional mission and provide a check on the other branches and adjudicate the rights that they're supposed to be adjudicating. So my paper explores strategies for the courts to secure their budgets and, as necessary, to fulfill their constitutional mission. The first, we talked about how the weapon of the judiciary is its judgments. The judiciary can rely on inherent powers, separation of powers doctrine, in order to compel funding through constitutional review. So this applies to salaries, which are protected explicitly in state and federal constitutions, and implicitly other expenditures where they're reasonably necessary for courts to carry out their mission. And then separately, more cooperative approaches, courts have leaned heavily on performance measures to arm court administrators and judicial councils with data in order to strengthen and sharpen their budget justifications. And communication strategies, including lobbying efforts and funding coalitions, elevating spokespersons of the judiciary, and monitoring impacts in terms of stakeholder losses. These are things that legislatures tend to be responsive to. And so this is rooted in separation of powers doctrine. So John Marshall, in debates over the ratification of the Virginia Constitution of 1831, said that the greatest scourge an angry heaven ever inflicted upon an ungrateful and a sinning people was an ignorant, a corrupt, or a dependent judiciary. So we're establishing the twin goals, really, of independence and accountability of the judiciary, which are heavily tied to public trust and confidence in the courts and the effectiveness of its rulings. And I'll provide some quick background. I don't have a lot of time, but Article 3 provides that the judicial power of the United States is vested in one Supreme Court. Congress is responsible for creating inferior courts, the appellate courts, and the district courts. There's a compensation clause, which provides that salaries and compensation should not be decreased during term in office, and tenure is during life with good behavior. There's a statute that provides that judicial branch budgets, which are drafted by the Administrative Office of the Courts and approved by the Judicial Conference of the United States, are submitted to the president, who is able to comment on but not revise the budget before submitting it to Congress, which approves it through a normal appropriations bill. So the state courts, they also have a constitutional role in separation of powers. The state constitutions create the judicial power of the states. State courts interpret the constitution of the state. The state constitutions examine the structure of the court system, administration, removal and disqualification of judges, selection and qualification of judges, and budgeting authorities. And there are different models for budgeting authorities. New York's model is similar to the federal government, where the budget is transmitted to the governor and included without revision in the budget, which is passed on to the legislature. California has a balanced budget amendment, which requires the governor to reconcile the entire state budget before submitting it to the legislature, including the judicial budget. So when we're talking about compelling funding, one of the most kind of explicit and common places this might come up is in judicial salaries. The Supreme Court has held that this is not a benefit for the judges. It's the point of the judicial salary compensation provision is to promote the independence and action of judgment, essential to the guarantees and pervading principles in administration of justice. So generally, direct reduction of judicial salaries is not very controversial. Sometimes legislatures will become clever and think about indirect ways to reduce judicial salaries, sometimes with animus against the court, sometimes not. But the Supreme Court has held that taxes, clawing back compensation with taxes, violate separation of powers when it is singling out the judiciary for unfavorable treatment. So income taxes that are generally applicable to all citizens do not necessarily violate that principle. And some of the states have dealt with pension contributions, increasing pension contributions, non-salary compensation. And the New Jersey Supreme Court held that the pension contributions could not be increased during the term in office. You could increase the pension contributions for executive officials, you could not for judges. Although you could potentially offset that by withholding salary increases in the future, was what they held in that case. Cost of living adjustments come up. There's a reason there's no fixed rate of compensation in the Constitution. The reason is inflation. So James Madison in Federalist 79 said it's necessary to leave it to the discretion of the legislature to vary its provisions according to judicial salary increases based on inflation. And back at the time, there was no agreed upon measure of inflation. Today, we have consumer price indexes and things that are more generally part of a consensus. But even then, those measures might be debatable. And also, so the Supreme Court held that when this compensation vests, so the legislature might promise cost of living increases in the future, those vest when they take effect as part of compensation due at the start of the fiscal year, was what the court held in U.S. v. Will. And state courts, I think this is a Michigan Supreme Court decision, I forgot to cite it, held that just whether cost of living adjustments are required by separation of powers. In this case, the court held that inflation is not an act of the legislature. It is not a diminishment by the legislature of judicial compensation, and therefore doesn't violate separation of powers. So the question has come up not so much in the federal courts, but often in the state courts. There's a long tradition of this, mostly at the local level, about whether the same principle applies outside of salaries. So, the judges can't operate without facilities, without air-conditioned offices, desks, staff and clerks to help them. When does the legislature go too far in cutting the budget in a way that impairs the constitutional mission of the courts? And there's a case from Pennsylvania from the 1970s that's pretty heavily cited and used as a persuasive authority that held that the courts can compel the legislature to provide money which is reasonably necessary for the proper functioning and administration of the courts. What is reasonably necessary is kind of a fact-intensive and difficult question to answer. But in the trial, this often it would come up where trial courts would sue a county board of supervisors in order to compel funding for some specific line item. Facilities where there's noise pollution that impairs trials, court probation officers, janitors, $86 for a tape recorder. The Pennsylvania Supreme Court held in LaBelle v. Coke, another case that the burden is on the judiciary to prove that their funding requests are reasonably necessary to the proper administration of the courts. And in this case held that, court employee salary increases were not proven to be reasonably necessary. Over the latter half of the 20th century, the conversation about this changed, and the role of the state Supreme Courts in overseeing these budget disputes changed because a lot of states gave supervision over the trial court budgets to the state Supreme Court and to the state judicial councils. So previously they had been mediating between, local disputes with relatively small amounts in controversy. And now we're negotiating on behalf of the trial courts for, with a peer level highest legislative officers to secure budgets for the entire judicial system. So that really kind of changed the conversation about judicial budgeting. So kind of separate from whether the judicial budget, the judiciary is adequately funded, there have been some cases about impermissible purposes of the legislature, funding conditions that violate separation of powers. There was a case called Marin v. Silber in New York, where the legislature conditioned judicial salary increases on legislative salary increases. They would not approve a judicial budget that did not include legislative salary increases for themselves. And the governor continued to veto it. And those judicial salary increases, cost of living adjustments that hadn't gone through for over 10 years, were basically held hostage as a bargaining chip. And the court held that that was impermissible, that compensation increases must be based on an objective assessment of the judiciary's needs. So this is just an irrelevant consideration, and directed the legislature to just knock it out, basically. Go back and, look at this problem of adequately funding the judiciary in good faith. And this could also apply. There have been cases. There was a case in Kansas where the state legislature conditioned the judicial budget on the outcome of a case where the legislature had passed a bill changing the administration of the trial courts and the supervision of the state Supreme Court over the trial courts. And they put a non-severability provision in a budget that said that if the court overturned that, then they would strip their funding. And the court was prepared to fight that using basically this reasoning. But before that happened, the legislature reversed course and repealed that measure. But similar logic might apply in those cases. So there are limits on this. The courts have recognized they can go too far with this. There's risk of embarrassment for this. There's a rule of necessity where ordinarily judges would have to recuse themselves in these cases because they're ruling on their own salary increases, potentially their own support staff as well. And but there's a rule of necessity because there's nobody in the entire judicial system could rule on these cases if everybody had to recuse themselves because they're dealing with their salaries. But that's still, there's a motivation there that the public is sensitive to. And further limits, and then another issue would be if the court goes too far and compels funding that is not reasonably necessary, then they have arrogated a duty reserved by the Constitution to the legislature. They violated separation of powers by trespassing on the legislature's fiscal oversight. So those are two principal concerns. And then in addition, it might just affect and continue if there's a strained relation between the branch and they want to repair the strained relation between the branches in order to secure long-term funding support. They want consistent budgets, not to have to sue every year. Then this might not be the right approach. So as another strategy, courts have sought to demonstrate their value, their public service, their accountability, their reputation, which is built up through transparent judicial budget requests. And part of this is leaned on performance measures, arming court administrators with data when they go into these budget negotiations to show how funding is being used responsibly, what goals of the judiciary are being accomplished, and how you can quantify those things. These are elements overwhelmingly of strategic plans, both for the state courts and the federal court system, implementing performance measures. And the Conference of Chief Justices and the Conference of State Court Administrators and the American Judges Association endorsed trial court performance measures developed by the National Center for State Courts. These include things from access to fairness, which they have a survey developed for that, clearance rates, time to disposition, trial date certainty, compliance with collections, and court employee satisfaction. And implementing these has been difficult due to the lack of data quality and lack of data availability. A lot of trial courts only really collect data on an ad hoc basis, and if it's not part of like a case management system, if it's not captured by the case management system, the data simply does not exist. But the goal of the performance measures really is to provide precise data definitions that allow cross comparison between courts and court systems. A lot of states have adopted these. So California publishes the court statistics report using the court tools on clearance rates and time for disposition. Massachusetts has done something similar with clearance rates, time to disposition, and age of pending cases. Many states have used this access and fairness survey. And there's also a global performance measures as part of the International Framework for Court Excellence, and 9 of the 11 measures in that are adapted directly from court tools. There's been some criticism about this. You know, judges are sensitive to kind of management techniques which seem to push at their discretion. It's not coming from another branch, it's coming from within their own court hierarchy. Their salaries are protected, their tenure is protected, but they could be subject to even just peer pressure from the other judges who feel like they're not pulling their weight and who push them to adopt management techniques, settlement conferences, mediation, any number of other things in order to push their docket along. There's also been criticism that, you know, studies over-focus on timeliness measures, kind of at the expense potentially of access and fairness measures. I'm not entirely sure that's true. I think that courts generate a lot of survey data. It's qualitative survey data. And they're interested in knowing public trust and confidence. But there's a problem there where it's hard for anything you do to improve timeliness. You want to know, how does that affect another performance measure? If that performance measure doesn't exist or the data is inadequate, then it's hard to know what effects that you're having on court users. And then separately, so other strategies for long-term support, you have positioning leadership as spokespersons for the judicial branch. The Chief Justice carries a lot of credibility and weight, even though they might not have all the technical know-how of the state court administrators. And, you know, building coalitions with allies of the court system, including businesses, inviting businesses to advocate on behalf of the judicial branch. South Carolina is an example of this. The state legislature, after the 2008 recession, enacted really just draconian budget cuts. 40% of their budgets were eliminated, and their strategy for dealing with that was to invite Boeing company to talk to the legislature. And so there's risks to some of these strategies. I mean, how the courts position themselves close to interests that appear in their courts. The perception that they have a partnership and an alliance with special interests, essentially, outside of the courts in order to secure their funding. But that could be a strategy that's successful. That's a general lobbying strategy that legislatures are responsive to. Also, researching and publishing information about how funding cuts will affect, you know, investment losses based on time to disposition. That's not something that the courts necessarily have good data on or information about, but it's something that
Justin, I'm afraid your time is up.
Oh, I'm sorry. Thank you.
Could you perhaps sum up?
Yes. I look forward to your questions. Thank you.
Okay, thank you very much, Mr. Representative. Okay, now we should move on to our first respondent, Dr. Said. Please, the floor is yours.
Thank you so much, Justin, for waking up very early according to United States time in order to give this presentation. And we truly appreciate that. What time is it, if I may ask, now at your country? Or at your
3:30 in the morning.
3 a.m. in the morning?
3:30. Yeah.
That's great. So thank you. The second thing is to give the comments on the paper. If I may summarize your overall argument, and please correct me if I'm wrong. So you are saying that courts are institutions that surely need funding in order to operate and in order to cover the salaries of its staff. In order to do so, the courts want to make sure that they get adequate budgets every fiscal year. They need all of that money in order, as mentioned in the slides, to have high salaries in order to attract good and proficient or qualified people to work as judges. If they want to seek or ask for a high budget, courts must show credibility. In order to show credibility, they must prove that their performance is a good performance. What standards should be considered? What standards we can rely on in order to see if the performance of courts is good or not? I couldn't get that very clearly from the paper. But from what you have said, you said that there should be certain standards that to a certain level must be agreed upon. But I believe that, of course, certainly you're right. Those standards are very, very hard to determine or to define. But at least we need minimum kind of standards in order to know how this court is acting. Is it being a productive court or not? Can we call it a credible court or not? The second thing, when it comes to reputation. Now, I understand your point when you said that if courts want to start campaigns or funding campaigns, then this might make a court looks as if they are self-motivating or trying to act to play the political furry game. But at the same time, we must not forget that courts are the third branch of the government, and this branch is under continuous threat by politicians who want to make sure that all of the judgments should be in their favor in order to defeat or at least lessen the chances of success for the opposite party. I understand that throughout your presentation you spoke about the legislator, but isn't the legislator in the United States, in fact, either the Republicans or the Democrats? So at the end of the day, can we say that the legislator, who is the Republicans or the Democrats, try always to make sure that they influence the judiciary in a way to continue to maintain and protect their interests as opposed to the interests of the opposite party or not? So that is the question that I would like to know the answer for. And that's it. And thank you so much, Justin, for the interesting presentation. Thank you.
Of course. As far as your first point about
can we perhaps collect
really how you can measure the necessity of judicial salaries, there are other things we could be talking about, but for judicial salaries in particular, I don't know if there's a good way of measuring that. It seems like courts, what they tend to do is they want to benchmark their state judicial salaries to federal judicial salaries or do comparative surveys with other states and just stack up how judicial compensation compares and then present that as a justification to the legislature. And often that's good enough, I think, as far as legislatures seem to be concerned, that they notice that judges could be paid much more if they were to go into private practice, and that creates a drain on the judiciary and a difficulty attracting talent and attracting qualified jurists. For other things, I mean, there are expenses outside of that. Court employee salaries might be difficult, but for things like if the courts are able to convincingly say that they would have to close or furlough a certain number of their workers, and that would impact access and open courts, that they're not able to literally stay open if they are not able to receive this funding, that's usually pretty compelling as far as something that's reasonably necessary to fund the judiciary. If the legislature were to take away all of the facilities for the court system, that would be going too far. I don't think anybody would really question that, but it's a difficult thing to say what is reasonably necessary. Sorry, I'll move on, but I was trying to remember what your third question was.
So the second question was, yeah, of course. Second question was was about the issue of politics, referring to the legislator as the legislator, while in fact the legislator is either the Republicans or the Democrats are trying to use the judiciary against the interests of the other party. I understand that the bottom line of your argument, as you mentioned in the last slide, that if courts are being too forceful or being not forceful enough, that they won't get the funding that they need to maintain their credibility. But again, to what extent the credibility in the eyes of the people is more important to the court than the credibility in the eyes of the party that is controlling the legislature?
Right. I think ultimately, I think my point was that the court's ultimate goal here is not necessarily funding. It is funding, of course, but it's that people take seriously its judgments, and things that the courts might do to attract funding have effects on that. There's no clear answer, really. It's just there are different risks and benefits to one approach or the other. And of course, the legislature is politically motivated based on what party controls it. That's just kind of part of the game that they have to play. And they can establish boundaries when the legislature, what party is in control of the legislature, has gone too far and violated separation of powers, either by not adequately funding the judiciary or by insisting on things that are not appropriate to insist on. So I hope that answers your question, or tries to.
Thank you, Justin. So moving on to our second respondent, Dr. Irfan.
Thank you, Mr. Chair. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, everyone. Hi, Justin. This is the second meeting. Nice to see you again. We have already discussed this topic in the 13th floor in our room in Toshiro Court building. Do you remember? Yes. After I reading your paper, first I would like to appreciate for your insightful presentation, and after reading the paper, I really enjoy the fruitful discussion related to the experience in keeping judicial independent in the U.S. As mentioned in your paper, I assume when the court need to get the budget, they have to submit a proposal to other branches, and I have three questions related to the paper. First, practically speaking, how to prevent political and transactional interest while the court coordinates to the other branch when submitting the budget proposals in order to prevent its program for coordinating to influencing the judicial independence by other branches. And second, you mentioned at the paper that there are three research questions or three problems to discuss, but I emphasize only to the third research question or discussion, which is explore connection with judicial independence of the Constitutional Court in Indonesia, identifying overlapping problems and applying possible strategies. According to the third research question or discussion, and after joining in an internship program at the Constitutional Court of the Indonesian a month ago, what is your suggestion in reformulating concept to the improve judicial independence in Indonesia, especially related to the budgeting independence? And the third is, it is an idea to regulate it and put the nominal budget in the constitution, such as 1 or 5% or 10% from the national budget to ensure the judicial budgeting independence without propose to other branches. What do you think about it? That's all. Thank you very much.
For the third question, I'm very skeptical of that, actually, assigning a percentage, because if the government goes through a period of austerity and is now categorically just slashing budgets across the board for all the executive agencies, if it's a percentage of the total budget, then that justifies, or it would be constitutionally permissible to also cut the budget for the court system. If you eliminate 50% of the funding for the executive branch, you could also eliminate 50% of the funding for the judicial branch. So I'm not sure that that's necessarily the best approach, because it ties it too much, I think, to how the legislature is managing the executive, and it should really be thinking about that independently, I think. And for your second problem, as far as, yeah, I did actually, that was a revision error, really. I intended to talk about that more, but it didn't make it into the paper. I'm hoping that I can strengthen that with my conclusions as we continue to edit it. But there are significant differences, I think, in the budgeting authority between the American courts and the Constitutional Court, both how court employees are positioned within the civil service and how the oversight of the judicial budget works. and the role of the executive in overseeing the judicial budget. It might be similar to some states in the United States, but it's not really very similar to the federal judiciary in the Supreme Court, I don't think. But as far as whether the Constitutional Court could apply this kind of doctrine of separation of powers to say that if the DPR were to punish the judiciary by cutting funding for the Constitutional Court based on its decision in order to intimidate it, this could be a doctrine or a principle of separation of powers that is analogous between the United States and Indonesia, that the Constitutional Court could potentially rely on. I don't know if there are other issues that would come up with that, but it could declare that has simply violated separation of powers, and that separation of powers is located in the Constitution, structurally and textually. So that's one option to consider. And then for your first question of how to prevent transactional interest, I guess I'm not entirely sure what you mean by transactional interest. If they're talking about forms of corruption, there are, for the Supreme Court, there might not be very much because they haven't adopted an ethical code, and there's no external oversight of the Supreme Court except for impeachment by the legislature, which is the political process. But in the state courts, at least, there are judicial conduct commissions that will investigate allegations of corruption that are credible and make a recommendation about sanctions or removal. But that doesn't apply the same way to our Constitutional Court and the federal government. Yeah, sorry. Do you have any other? I hope that answers your questions. If you have any follow-up, let me know.
Okay, thank you, Justin. Yeah, I still remember during the COVID, we had budget cuts. I think also the Constitutional Court was also impacted. The Ministry of Finance is quite powerful for every institution in this country. I will now take questions from Zoom first and then from the audience in the room. I will read the Zoom questions. There is question from Aldi Hermansyah, a law student from Indonesia. He wanted to ask how much influence the budget confrontation has on the decision or performance of judges in states across America. So that's the first questions. Now I'm going to collect questions from inside the room. Do you have any questions from my right-hand side? From my left-hand side? Any questions? Okay, there are no questions. So there's only one additional question for you, Justin. Would you be able to answer that? Sure. Thank you.
Well, I think it's important at least that judicial salaries are insulated from that, and other forms of compensation as well. So it's not as though they are going to be facing a salary reduction based on how they perform and like a performance review as you would as an employee, according to measures in a human resources database. That's not something that they typically worry about, but there could be filtered down effects, I guess, if the budget kind of systematically prefers something like, alternative dispute resolution or court-ordered mediation, and that we notice that this court is doing this and this court is doing this, and, kind of putting more subtle pressure on judges through the budgeting process. That's something I could potentially worry about. I guess I don't have very good data or information about it, but it's something that I am concerned about.
Thank you, Justin, for your presentations. Let's give big hands to Justin and our respondent. I think this concludes our session for today, ladies and gentlemen. I cannot conclude anything, but it seems like I feel that democracy is really hanging in a thread because of these different institutions competing each other. So it needs some kind of balance. So if there is something wrong with the yin and yang, and then they may come to the dark side. So that's probably my takeaways. So again, thank you very much for your attention. I'll leave it to the master of ceremony. Thank you.
big applause to the chair, speakers, and respondents of the session 5. And now, Excellency, ladies and gentlemen, we have spent 2 days along with 5 chairs, 14 speakers, 18 respondents. We had discussed upon the Constitutional Court and judicial independence, a comparative perspective. And now we finally reach the final agenda of the 6th Indonesian Constitutional Court International Symposium 2023. And in prior to the closing remarks by Constitutional Justice, His Excellency Daniel Yusmik Pancastakifoeh, I would like to invite Mr. Pan Muhammad Faiz, PhD, as Head of Research, Case Study, and Library Management to deliver report and conclusion of the holding of the 6th ICCIS 2023. The floor is yours.
Thank you, Ms. Ofi. Your Excellency, Dr. Daniel Yusmik Pancastakifoeh, distinguished speaker, my colleagues, beloved colleagues, respondents, ASLI, we call it ASLI, Assistant Ahli Hakim Konstitusi or Expert Assistant to Justice of the Constitutional Court. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon. May peace and prosperity be upon us. It has been a very fruitful discussions. We've talked and discussed many important things related with judicial independence, not only in Indonesia, but also experience in many countries. We discussed Palestine, we discussed also Philippines, we discussed Australia, Mexico, El Salvador, Hungary, even we touched Polandia and other countries. It become a very good insight for us, especially the Indonesian Constitutional Court. And it's not easy to, let's say, implement that every principles presented by speakers. We know that the discussions is still left a debate or discussion, but we can have a further discussions after this. Before we close these sessions and His Excellency Dr. Daniel Yusmik address his closing remarks, I would like to give an opportunity to any speakers or even respondent to give your opinion or testimony on this event. So it's not just a very formal one. I would like to invite first Dr. Monica.
Sure. Thank you, Faiz. Well, I do consider like there cannot be a better time for us to discuss and reflect the contemporary challenges on the independence of the judiciary from this comparative perspective. And I would like to take the opportunity to congratulate the members of the Constitutional Court of Indonesia for creating a safe and professional forum for us to be able to share our professional and academic experiences with this topic, with all these distinguished panelists. And I also believe like this is a quite unique conference for many reasons, but especially because in addition of promoting this safe and objective dialogue on this very important topic, it gave us the opportunity to interact directly with the members of the Constitutional Court. And to me, this is an invaluable and memorable experience that I will take with me for the years ahead. So finally, I would like to also congratulate Dr. Pan Muhammad Faiz for this impeccable conference, and thank you so much for giving me the opportunity to share my reflections and commentaries on some topics that are very interested to me. Thank you so much, Faiz.
Thank you, Dr. Monica. We have representative from a left wing, now from right wing. Probably Professor Tim Lindsay, you want to say something about this event?
It's the first time I've ever been called right wing in my life, possibly the last. We've all heard yesterday and today that the Constitutional Court is 20 years old this year. It is the first court in Indonesian history that's had the power to review national legislation. This meant that before 2003, Indonesia had a tumultuous history of effective legislative impunity, with lawmakers not subject to any form of real judicial accountability or review. And that in turn meant that a politician, usually a president, who was able to obtain effective control of the legislature in Indonesia, was able to enjoy virtually unchecked dictatorial power. And of course, the absence of constitutional review meant that is what has happened under the first two presidents of Indonesia, Sukarno and Suharto, in quite different ways, but both were able to exploit the fact that laws could not be checked or reviewed. The result was that after the second president, Suharto, fell in 1998, there were hundreds of unconstitutional laws that were identified on the books, and a long period of reform came out. And this new constitutional court that we're celebrating 2 decades of now was specifically established to remedy that situation, to stop it happening again, for it to act as a guardian of the Constitution. And doing that, its job included that it was intended to be able to defend the integrity of a constitutional democracy against the power and ambitions of the executive and legislative branches, which are in a sense inherent, as Indonesian history showed. So it was specifically intended to prevent what had happened with the first two presidents. Now, the Constitutional Court in those 20 years has had its fair share of problems and challenges, some very severe, many external, but some internal as well. But it's fair to say that the court quickly surpassed the expectations of observers who, to be frank, many didn't think it would succeed at the start. It has certainly succeeded, both in terms of courageous decisions, asserting independence, and introducing something we didn't cover, but introducing a new tradition of more detailed, thoroughly reasoned judgments, which I think is an important legacy. But a number of speakers over the last couple of days have agreed that 20 years is a very short period in which to establish a new judicial tradition of independence. Independence, whether it's established on the basis of rules and legislations or on the basis of the court's own interpretations and decisions, or that most mysterious element of culture. But after 20 years, that means the court still faces challenges, threats, and many problems remain, especially after a judge was dismissed last year. These 2 days have given Indonesian jurists and colleagues from around the world the opportunity to discuss all of these issues, and from a comparative perspective, comparing the experiences of how courts are to be defended, particularly constitutional review courts are to be defended. And all of us, I think, will take away something very valuable from that, but it is my real hope that our Indonesian colleagues take away the most from this event. So I'd like to thank them for the opportunity to sit here and speak so frankly, which is itself a real testimony to the power of this court, and to the judges of the court for allowing us to do so. Thank you.
I would like to invite any speakers who also want to give a short testimony or comments. Anyone? Oh, outside. Please, outside.
I don't want to do something bad, which is to prevent anyone from going outside and in this conference. But I should say that I was positively envious of the constitutional scholars here in Indonesia. And what I mean by positively envious, it's a translation of the word ghibta in Arabic, which is different from hasad. Hasad is when you are envious and you wish for the blessing that someone is enjoying is to be removed, while ghibta is to be happy for him and wish that the same thing happens to you. I was the first Palestinian to write a PhD thesis about the independence of the Constitutional Court. And since I have come back to Palestine 4 years ago, I have been completely disregarded and abandoned to participate from any event that was held by the Constitutional Court. I'm not sad. I do not expect anything less from judges who were single-handedly appointed by the president. But I should say that it was very heartwarming for me to see all of the judges sitting here and see constitutional scholars providing criticism to the judges, and the judges accepting this criticism with an open heart. So that means a lot. And when I come back to Palestine, I won't be very fussy about participating in any event by the Constitutional Court, but I will always make sure that I stay as a vocal sound, as someone who is always blowing the whistle, saying that this court is just being used as a legitimizing tool in the hands of an 83-year-old president who has been residing in the presidency for the last 18 years against the Constitution. So thank you for teaching me this touching meaning, and I will always keep it and treasure it. Thank you so much, and jazakumullahu khairan.
Now, Professor Simon,
yeah,
please.
I couldn't let this opportunity go because when I go back to Australia, people will not listen to what I say. So I'd better take the opportunity now. But very short, because I think Prof. Tim has said everything that I would have said, except I would add, when we were sitting here yesterday morning, Professor Jimli Asadiki, the first Chief Justice, was the one to raise the elephant in the room, the big case that I think may have inspired the theme of this conference. And he, I think, just like he did with the beginnings of the court, where he kind of forged the way ahead for a new institution, I think set the tone for this conference. And a number of people have said, it's an amazingly free environment in which we feel free to say our opinions about what the court has done. Prof. Saldi also said it's like medicine for the court. Now, if that's true, then the medicine is not very tasty. Yeah, it's very bitter medicine. But it's a privilege to be able to do research about this court because the court is so receptive. And so it's fantastic to come together with friends and colleagues to give some comments about what we all really deeply respect and enjoy working on the court. So thank you again for the opportunity.
Thank you, Simon. It is the way that we introduce Indonesian Constitutional Court, and we also open for any comments, opinion, or even criticism. It's kind of like a medicine, and this is the environment that we built since the leadership of Professor Jimli, the academic atmosphere. So this is not the first one, and we do hope that this is not the end of our relations or communications. We hope that after this conference, we could build a network from one country to another country. So anytime if you want to research about Indonesian Constitutional Court, we could also support the data. If you want to visit the court, we can have discussions, and all the colleagues, court staff, they're also open to have a discussion. Even every week, almost 3 or 4 students, not only from Indonesia, but also from overseas, they come and visit Indonesia to do research. So we all hope it is a memorable conference, and please send our warm regards to your college and university, to the court, and also especially regards for Justice Leonen from the Philippines. It's a very honor to have both of you as a representative from the Supreme Court of the Philippines. So I will end up here, and then we will listen to the closing remark from Honorable Dr. Daniel Yusmik Pancastakifwe. Thank you.
Thank you, Mr. Pan Muhammad Faiz. Assalamualaikum warahmatullahi wabarakatuh.
May peace be upon us. Om Swastiastu, Namo Buddhaya, Salam Kebajikan. Salam Pancasila. Distinguished speakers, respondents, and participants of the International Symposium, ladies and gentlemen, let us offer praise and gratitude to the Almighty God who has bestowed upon us His blessing so that we can attend the closing session of the 6th Indonesia Constitutional Court International Symposium this afternoon. Distinguished speakers, respondents, and participants, we have just successfully completed an international symposium which discussed a very interesting theme, namely constitutional court and judicial independence, a comparative perspective. During these 2 days, we have heard many opinions and views from academics and practitioners. I observed no less than 12 speakers divided into 5 sessions who have conveyed various ideas and concepts that have been discussed by respondents and participants with various comments, feedback, and also critical questions. Various perspectives regarding the independence of the judicial have been presented from many countries, such as the Philippines, Australia, South Korea, Hungary, Poland, Mexico, El Salvador, and others. Apart from that, the issues of the independence of the judiciary in Indonesia was also studied in depth by several speakers. During the symposium, I have closely followed all the speakers at each session, both delivered online and in the person of this venue. I noted that His Excellency, Senior Associate Justice Mario Victor Famor Kalenon, presented by Ms. Ruby Alberto, spoke about Philippines constitutional adjudication, balancing fundamental liberties and government powers. Professor Adrian Menzifar from El Salvador spoke about the removal of the Constitutional Chamber justices in El Salvador. Meanwhile, Professor Tim Lindsay delivered an in-depth study regarding the independence of the judiciary. Professor Lindsay compared the independence of the judiciary in Indonesia and Australia. Furthermore, Professor Sang Hyun John highlighted the composition and appointment of constitutional court justices in South Korea. According to him, these things are very important to maintain the independence and professionalism of the Korea Constitutional Court. The challenge to the independence of the judiciary was also presented by Professor Sultan Sente from Hungary. In this opinion, the phenomenon of the decline of democracy throughout the world poses a big challenge to the independence of the Constitutional Court, which is the guardian of the Constitution and the rule of law. Professor Sultan gave an example of several cases in Hungary, which ultimately undermine the independence of the Constitutional Court. Also discussing Hungary, Dr. Idul Risham explained the various causes of the weakening of the independence of the Constitutional Court of Hungary, Poland, and Indonesia. He argued that at the beginning of their long struggles through political transition, the Constitutional Court served a very important role in the development of law and the protection of human rights. However, in the period of the following drug amendments to Constitution and the revision of laws, the independence of constitutional justice became weak, and this has impacted institution independence. I also paid attention to the presentation delivered by Professor Simon Beth, who discussed Constitutional Court decision on the judicial independence of other Indonesian courts. Regarding this, Professor Mirsa Satria Buana stated that the judicial review authority of the Constitutional Court has gradually shifted from strong form review and weak form reviews. In this presentation, he explored comparative insight from various countries, particularly the United States, strong form review, and Commonwealth countries, weak form review. He hopes that the Indonesia Constitutional Court return to its original authority as a strong form review to strengthen the foundation of constitutionalism. On the other hand, Dr. Monica Castillejos Arago describes the relationship between populist rule and judicial independence in Mexico. By taking the case of her countries, she stated that there has been political interference in the independence of the judiciary. Telltale signs that should be watched out for in order to control the judiciary are cutting the judge's salary, political reaction to unfavorable court decision accompanied by political intimidation and impeachment, as well as a series of draft regulations proposed to undermine the judiciary. All of their action, according to Dr. Monica, have undermined the independence of the judiciary in Mexico. Dr. Fritz Edward Siregar presented his research on the reliance of the judiciary in resisting populist pressure in South Africa, Colombia, and Indonesia. In his opinion, there are 4 steps needed to protect the independence of the judiciary, namely, first, strengthening the legal and institution framework; second, cultivating a culture and uphold the principle of a rule of law; third, increasing judicial accountability and transparency; and fourth, encouraging dialogue and cooperation between judicial entities. Amidst the challenges of the populist movement, he underlined that public support is very important to help the judiciary gain legitimacy so that the judiciary will be more authoritative and effectively implement its decisions. Regarding the threat of the populist religious movement to the independence of the judiciary, Mrs. Chakli Setia Prativi said that the populist religious movement had attempted to influence the judiciary and this had application for democracy and the rule of law in Indonesia. This movement advocates for policies consistent with their religious beliefs and view the justice system as a tool to further their agenda. According to Chakli, this is a serious threat to the independence of the Indonesia Constitutional Court, which is required to be impartial in interpreting and applying knowledge. Interesting was the presented delivered by Dr. Osaid Awarda from Palestine. He discussed the criteria for assessing the jure judicial independence according to 4 international documents, namely, first, basic principles on the independence of the judiciary by the UN. Second, report of the special reporter on the independence of judges and lawyers. Third, the Universal Charter of the Judges. And the fourth, international principles on the independence and accountability of judges, lawyers, and prosecutors. The 3 key elements of the jure judicial independence include personal, institutional, and procedure aspects. He emphasizes that the principle of judicial independence aims to protect judges from unauthorized interference from the branch of executive power, especially in terms of the process of appointment and dismissal, the term of official of judges, the jurisdiction of the court, and the administration of justice in general. In addition, I also noted what they explained by justice be a person according to him, while some courts have funding, protection for salaries, and necessary staff facilities, technology, and equipment, the judiciary in the United States General relies on allocation provided by the legislature to fund the need of the courts. The court has tried to improve good relations with other balances of power, though strategy planning and performance measurement. On the other hand, courts also sometimes use their inherent power to coerce funding from legislative and executive officials, even though this tends to undermine respect and cooperative partnership with other branches of power. With all this notes, it must be admitted that this symposium was not intended to provide solution to all challenges relating to the independence of the judiciary. More time is needed to discuss specific issues in greater detail. However, the symposium has opened a discourse on issues that might receive less attention in comparative study of constitutional law, particularly with regard to the independence of the judiciary. Distinguished speakers, respondents, and participants, the Indonesia Constitutional Court has collaborated with universities throughout Indonesia to raise awareness of the Constitution and Constitutional Court decision. The Indonesia Constitutional Court also cooperative with various universities abroad. For example, with William and Mary Law School in the United States, University of The Hague and the University of Maastricht in Netherlands, the University of Leipzig and the University of Erfurt in Germany, Curtin University and the University of Newcastle in Australia, Malaysia International Islamic University, as well as several research institutes, such as the Max Planck Foundation for International Peace and the Rule of Law. The question is, why did the Indonesia Constitutional Court seek to establish such international cooperation? Because we believe that investing in human resources will make the Indonesia Constitutional Court better as it strives for excellence both in case management and in the decision-making process. We always encourage our employees to observe and study current issues surrounding constitutional law and justice in various countries in an atmosphere that uphold academic value so that they can provide substantive support to the court justices. Therefore, the Indonesia Constitutional Court is open to collaborating with universities and research institutions affiliated with the speakers and participants of this symposium. On this occasion, allow me to invite you to all submit a manuscript to the Constitutional Review Journal, so that these ideas and opinions can be read by justice, lawyers, and legal scholars in various parts of the world. The Constitutional Review Journal is a scientific journal managed by the Indonesia Constitutional Court and has been indexed by Scopus, making it one of the most trusted reference in the field of constitutional law. In closing, I would like to thank all those who have made this symposium a success. Hopefully, this global academic forum can inspire more discussion to come. Likewise, I hope all of you can enjoy the beauty and hospitality in Jakarta. Once again, thank you for your attention, ladies and gentlemen. On this occasion, I officially close the sixth Indonesia Constitutional Court International Symposium agenda. Thank you. Wassalamualaikum warahmatullahi wabarakatuh. May peace be upon us. Om Santi 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 Om. Thank you.
Thank you, Excellency. Ladies and gentlemen, the next session is called Certificate of Appreciations. I would like to hand over certificate to the representative of each categories of the 6 ICCIS, speaker, chair, respondents, and committee. And those whose name called, please come forward to receive the certificate handled by His Excellency Dr. Daniel Yusmik Pancastakifoy, and others will receive the certificates delivered to your email. So one, I would call the speaker, the Attorney Ruby and Teresa L. Alberto from the Supreme Court of the Philippines. Please come forward. Second chair, Dr. Heribertus Jakatriana from Law Faculty of University Gadjah Mada. The third respondent, Dr. Abdul Gofar from the Constitutional Court of Indonesia. And the fourth committee, Siti Rosmalina Nurhayati from Constitutional Court of Indonesia. So, His Excellency, please hand over the certificate to 4 people. The first, to the respondents, Dr. Abdul Gofar. And the second one is from the committee, Siti Rosmalina Nurhayati. And the third one is Chair, Dr. Heribertus Jakatriana from Law Faculty of Universitas Gadjah Mada. And speaker, Attorney Ruby and Teresa L. Alberto from the Supreme Court of the Philippines. Thank you, and now take picture together. And for His Excellency and Head of Center for Research, Case Study, please stay. While I would like to invite, similar to group photo session yesterday, I would invite the first batch, the speakers and chairs, to come forward to take pictures together. And then the second batch will be respondents, and the last will be the committee of the 6th ICCIS 2023. Please come forward. The first batch, the chairs and speakers. Please wait. The chairs and speakers. Okay. Oh. Let's make it centered. And then done. Okay, now we invite the respondents. The respondents and also the committee. Okay, Respondents and committee of the 6th ICCIS, please join the group photo online, group photo sessions. Thank you. You may be seated. So, Excellencies, ladies and gentlemen, the 6th ICCIS is officially